If I didn't have those two gentlemen behind you right now, you'd run off again. Every time. Yes, that's what you do.
I can't run.
What?
I can't run.
You can't run?
I can't run. Never.
I know, because you kept running before. And that's why you're here right now.
Good morning, Your Honor. D'Amico Cummings for the record.
Please declare on behalf of probation, Your Honor, Mr. Cummings is before the court for a violation of probation hearing. Mr. Cummings did have a prior VOP hearing on June 12th. At that date, the court had ordered him to serve 10 days in jail for his violations to date. Mr. Cummings failed to report to the jail as the court ordered him to do that, and the bench warrant was issued. He has been since picked up on the warrant, has been in custody. At this time, Mr. Cummings is still in the same situation he was on June 12th. He still has a balance of $1,255. He's made no payments to the court. He failed to complete the level 2 driver rehab program, failed to complete 100 hours of community service. He has another new pending case since June 12th, an alleged R&O, date of offense, July 22nd, 2024. He does have a PCC on August 1st in that case. So the court is also aware Mr. Cummings does have another pending case on 14B. It is a domestic violence case. He goes for sentencing on that on Monday. That is not a violation of this case. It happened prior to his sentencing. However, he also, in that case, has a bond violation as he violated the no contact order in that case. That will be addressed at their sentencing hearing as well. Mr. Cummings, in this case, Your Honor, it started as a felony case. We did get him sentenced in it. However, prior to all of that, getting him to sentencing in January, he had multiple failure to appears before this court. He continues not to follow court order. Given that he has demonstrated that he does probation, probation is recommending that he serves 365 days in jail, credit for 85 days that he served to date, to serve the balance, that he complete the in-jail MRT program with the court to consider early release upon his completion with that, and that he be discharged from probation without improvement with and waiving remaining terms, accepting his financial obligations.
You know, I did have a lengthy conversation with Mr. Cummings yesterday. He does admit that he messed up on probation.
So he admits to these violations.
Yes, except for the pending cases for obvious reasons. Frankly, he wants to ask the judge for mercy in this situation. He would like for his probation to be reinstated. He said he is willing to comply with probation and get done what he needs to do. However, he does want to take responsibility for not doing what he needs to do over the past couple months. So when I asked him what's been going on, he kind of gave me a litany of things. He cares for his 5-year-old son, who is going to kindergarten in the fall. He also has a baby on the way. His partner to the 14th, but really the baby can come any day. Those two things, as well as his job, he's working Amazon night shift 40 hours a week, essentially distracted him from taking care of what he needs to do on this probation. He does live with his mother and his partner, as well as his children, so he does have a support system. He says he can make payments. He is working full-time, and he does have some savings that he can put a pretty substantial payment toward his fines and costs. He said his mom can come up and pay $1,000 before he even is released from jail. He mentioned to me that he has been successful in other probations, and thinks he can be successful here if the court is willing to give him another chance.
How did he get picked up on this warrant?
The police came to your apartment for an unrelated matter. And Mr. Cummings would like to make a statement he wrote down Um,
Did you have something, Ms.
Your
Polari,
Honor, I just
before he?
wanted to say, when the police did arrive at the apartment, it was for an unrelated matter, and I believe that he ran, and that's where the new RNO case came from.
Go ahead.
I know. I want to start like this and say I do got a 4-year-old about to be 5 in October, about to start school this fall. I got a daughter due any day this month. Now I was working a night shift at Amazon, 40 hours a week, 10 hours and 30 minutes a day. I was laying down on my side, didn't look at it as a punishment, but I looked at it as an opportunity to do better and be better and get my life together. I can't have warrants and actually be responsible for my son and get to school every day or even to a bus. Please don't punish me or revoke my probation. I think y'all can actually help me do and be better. I signed up for Michigan Reenters to try to get back in school and see what college is like, even though it seemed like I haven't been trying. That's something me and my probation officer spoke about. I can and I'm willing to do extra classes like MRT free and on probation. I'll pay to start my driving class before I'm even released, if considered. And if you can take thought that I'm on probation for being a victim in a car accident I was in or at fault for, I went to the hospital with bad injuries, just as everybody else. Like, please, Your Honor, I've been getting dealt a bad hand. And I always have just been trying to be the best I can and resolve every issue the best way possible. Honestly, I'm not the best, but also not the worst. Like, please, Your Honor, I beg you, please, can I have one more chance to show y'all I actually had a bump in the road and I had to get over it, please. If you see me again, you can revoke my probation, give me a year or anything. Like, I really do and truly apologize for the confusion and decisions I left y'all left you and my probation officer to ponder with. But I really have just been working, trying to be there for my son and the mother of my child that's currently pregnant. Like, please don't punish me yet, but give me one more chance. Like, I'm actually a full-time father and my son stays with me. I can't imagine just leaving my son out the blue like this. He missed me as we speak and think I'm on vacation. I'm going to be a full-time dad to my daughter too, that's due. This is the first time you see me for a reinstatement and the last time if possible. I'd do anything to be there when my daughter is born and put my name on the birth certificate. I watched my son go off to start his first day of school. Your Honor, I plead and please, I'd do anything, even if it was double my community service, double my restitution, and add extra classes. I'd do it and complete it all. If you can, please consider everything I said and give me a chance. It would be the biggest and best blessing. I know I haven't paid yet, but I thought I had time to. I had kids, house, and life things to take care of. I haven't started my driver class because I was supposed to start it a month after being released, but I didn't have a job or was told that I had to pay to start it after being released. I know I haven't started my community service, but I checked in the places that let me serve the community legally to get this out the way. If I can, please have one more chance to show y'all. You wouldn't regret it, I promise. But that's all I have to say and ask of Your Honor. Sincerely.
Cummings, here's my problem. On September 13th, you were set, well, before that, I think I took your plea. You were supposed to appear for sentencing. Actually, I didn't take your plea. Looks like it was taken by another judge. But anyway, you were supposed to appear for sentencing. You were supposed to do a PSI with the probation department. This was back in September 2023. And you don't do any of that. And I have to issue a bench warrant. Somehow or another, it looks like that may have gotten set aside in January. And then I adjourned your sentencing January 9th. We had to somehow or another find you from September to January. And then on January 9th of 2024, I adjourned your sentencing. It was adjourned by probation to January 24th, 2024. You show up on January 24th and they give you a sentence. Relatively straightforward sentence. You were in custody at the time. And I laid out everything that you needed to do. That was in January. You really don't do anything on probation that I ordered you to do. So then you show up June 12th of this year on a violation of probation hearing. And at that time, and I think you were on Zoom, you were out. We told you the things that you were supposed to do or hadn't done and try to get corrected. And at that point, I kind of just sent a warning shot to you and told you, you got to do these things. And I ordered you and ordered only 10 days. And Ms. Polaro's trying to work with you too. I mean, we didn't order you serve the full time. We said, here are the things you haven't done. You need to get them accomplished. So I ordered 10 days in jail, gave you a specific day to report to probation on June 24th, 2024. Did you go?
I was in warrant status. I don't think I could have. Your Honor.
Oh, you could have.
You're right, for sure.
And then ordered you to become compliant with all the previous terms that I ordered. So I gave you another shot from January to that June day. The 10 days, because you were on Zoom, I told you exactly what I would do. I said you're to report by 6 p.m. that day, or I was going to issue a bench warrant without bond. You must have thought I was kidding.
No, Your Honor. Not.
Then why didn't you go?
I didn't make it by 6. I knew the deal could have been off the table. But I definitely was not thinking you was joking.
Why did you not turn yourself in then?
And I was
You
trying
want me to give you another chance,
to plead.
and you did nothing.
I could complete this probation. Promise.
What?
I can and will complete this probation, possibly, if possible.
You can't, you do what you want to do.
I'm gonna speak
When did you get picked up on this one?
about 20, if I'm not mistaken.
July 20th. Okay. So between June 12th, when I ordered you to report to the jail, and that day you got picked up, what were you doing to correct this?
I was trying to work, make sure I had some money, so if I had other bonds. But I do apologize, and I can't say this, Your Honor.
Here's my problem. You're apologizing because you got caught. You were, if those police had not come to your door that day, I still wouldn't be seeing you.
Yeah, I probably would have turned myself in still.
When?
That was all.
In the 45 days from the time that I ordered it to the time that you got picked up, at what point were you going to turn yourself in?
As soon as I had enough funds to take care of other cases that's holding me with no bonds and counties like tickets. And I was trying to be there for the mother of my child that's currently pregnant. I would have done my probation this whole time, but I had other warrants that stopping me from doing my probation. I'm not going to say, yeah, I didn't. I'm not going to say I didn't turn myself in. It was other warrants, other cases that stopping me from being best at what I can show y'all and doing my probation.
I've given you an opportunity to show me. I'm coming up on a year, and guess what? What have you done? Nothing. Nothing. And then you're gonna, and I try to give you at least a gentle nudge, and you still don't do anything. Nothing. You tell me one thing on this sentence that I gave you that you've done.
It was my first time.
Tell me one thing you did.
I checked in, it was hard. I mean, I did check in, do the non-report.
Why is it that you just can't say, Judge, I did nothing?
I did nothing.
Because I'm looking right at it. You did nothing.
You're right, Your Honor. You right.
Everything with you is an excuse.
No excuses as a man. That's what I was taught. So I don't try to make excuses, honestly.
You've made excuses since the time you first started talking. Everything that's come out of your mouth is an excuse. I sit here and I give you a chance to do it. We wait 6 months, correct something. Anybody that is on probation in my court, if, you know, and I feel bad sometimes for Miss Polera, but she doesn't mind doing it. If you're having problems, you'll walk in, you talk to her. But you wouldn't even do that. You thought this was a game. You thought when you looked me in the face on Zoom and I told you when to report that I was just kidding. Nothing that comes out of my mouth am I kidding. I told you to report. I told you when to be there. And I told you how long you'd be there. And I told you what I would do if you didn't report. And so you know there's a bench warrant out for you. Because at least you took me for real on that I was going to issue a bench warrant. So when the police show up, what do? You don't even say at that point, I got to deal with this. You take off running, allegedly, I guess we'll say at this point. And where was that going to get you? Got you right here. And after all that, Mr. Cummings, you want me to believe anything that's coming out of your mouth that doesn't resemble an excuse.
I don't got no reason to be trying to have warrant statuses and
You have no reason for any of this. Everything that has happened that's bad in this case is no one's fault but yours. And the problem is, had you gotten to your attorneys, had you gone through and you were truly going through doing something, hey, they would have helped you out. There's no doubt, Ms. Perrine or Ms. Pate, they would have been all over my coordinator's email, trying to figure out something to do. Quite frankly, even if you had at that point gotten to Ms. Polera, she would have been trying to do something.
I didn't want to be disrespectful, not.
Oh, too late. You disrespected everybody here. So don't even play that game with me that you don't want to be disrespectful. You intentionally were disrespectful. You intentionally thwarted my order. You intentionally then tried to hide and seclude yourself. You were disrespectful, allegedly, to the police when they showed up, told you had a warrant, you take off. Every move you made has been just coated with disrespect to everybody involved in the process.
I wasn't trying to be disrespectful, calling my probation officer and not coming in to take care of the business. And I didn't even talk to the police or anything. They didn't tell me anything.
Okay. You had a warrant, you knew it, you took off. And if I didn't have those two gentlemen behind you right now, you'd run off again.
Definitely.
Every time. Yes, that's what you do.
I can't run.
What?
I can't run.
You can't run?
I can't run. Never.
I know, because you kept running before. And that's why you're here right now. That's all that you've been doing. Doing nothing and running.
I haven't had the probation because I had warrants for other cases. I would be straight on track with probation today. It wasn't for the other warrants, Your Honor. I promise you.
So you're telling me you weren't doing probation because you had warrants? Yeah, why'd you have warrants?
That's the.
Why'd you have warrants?
Bond.
Because you hadn't done what you were supposed to do before.
They wanted me to turn my all type of. Your Honor, if I didn't have other warrants, I'd be straight on track with probation. Why would Miss Polaire is a good lady? I know you don't try to be as hard as you do or want to be, but
Oh, I don't. Mr. Cummings, I do not want to send you to
y'all
jail.
are not nobody.
Mr. Cummings, I do not want to send you to jail. I do not like sending people to jail. I try to bend over backwards to give people the opportunity. When you need a nudge, and I may have to do a little bit of time, I do a little bit of time, trying to at least get your attention, get you back on track. All of those things, every one of them. I've tried with you. And you've done nothing. I don't even have anything in this sentence I gave you the beginning of this year. I have nothing that I could point to say you did or tried to do something. I have nothing.
That's what's off paper.
I have nothing.
I'm sure, Honor, if it was
You could have, Mr. Cummings, understand this. Your promises are no good to me. Your promises are no good.
Can I say one thing? I wouldn't have this warrant for probation if I didn't have the other warrants. That's how my probation. And I wasn't communicating with y'all or doing what I was supposed to do or should have been. But that's not me though. I've for sure completed a probation before I could do and complete this.
You
case.
still got warrants.
Everything, this is what I had to take care of. If it ain't a ticket, this is the only things I had to take care of.
Your Honor, I think he's referencing the domestic violence case, that he did have a warrant for. But
he still does have a warrant out of 35th.
And he does have that drug license.
You don't take care of business. I can't help you. I really can't. Anybody that walks through that door that tells me they want to do something, want to follow what we say and try to work hard to try to change things, I'll help them. I know there's no two ways about it. And my entire staff, my probation staff, my staff, will help you do what you need to do. And I know your attorneys. If you had reached out to them, they would have helped you. You just didn't. You wanted to do it your way. And your way doesn't work. So now we're going to do it my way. And it's just going to be harsh.
Chance to show y'all I will take care of this. I promise you not see me again. If it ain't to be getting released off of probation early or anything.
I'm going to waive the remaining terms except the defendant's financial obligations. I'm going to discharge from probation without improvement. I'm going to order 365 days Washington County Jail. Credit for the 85 days that you served. Defendant will serve the balance. I will consider early release upon the completion of the MRT jail in jail program. I will consider release. I don't know whether I will release you, but that's going to be the first step you're going to have to do. You don't want to do it? You got 290 days to figure it out. I don't know why you just won't understand. I'm asking you, and I need a direct answer whether you understand what I am saying, not whether or not you're recognizing the words. Do you understand what I am saying?
I understand what you're saying.
You want to be,
Your Honor,
you Have a seat.
I'm not,
Have a seat.
Your Honor, I haven't had.
Have a seat. You can play games with me all day. I got all day. I got all day. Have a seat. State your name.
Good afternoon, Your Honor. My name is Daniel Magoo.
I have stated the admonishments that I was giving to the defendant representing himself. I apprised him of the maximum penalties and the charges. Apprised him, and sir, I'll ask you the question again. You understand that there can be great peril in representing yourself.
I fully recognize and acknowledge the seriousness of the charges, which include allegations of.
Not my question. You understand that there can be serious peril in representing yourself.
I recognize what you're saying, and I'm fully prepared to proceed with this matter.
Will you just do me a favor and answer my question? Do you understand that there is great peril in representing oneself?
I recognize that.
Okay, then stop there.
Yeah.
You recognize.
Recognize.
Do you understand that that in any of the proceedings that the court would hold you to the same standards as if you were a practicing attorney, will give no leeway one way or the other, will show no favoritism or no bias because you are representing yourself. You understand that, sir?
I recognize what you're saying, Your Honor.
You know what? I don't know why you just won't understand. I'm asking you, and I need a direct answer, whether you understand what I am saying, not whether or not you're recognizing the words. Do you understand what I am saying?
I understand what you're saying.
You want to be,
Your Honor,
you have a seat.
I'm not.
Have a seat.
Your Honor, I haven't had.
Have a seat. You can play games with me all day. I got all day. I got all day. Have a seat. The other one's in custody. I realize we are now at least caught up within an hour. I think those that want to go probably want me to take a break about now. So I'm going to take about a 5 to 10 minute break. I'll come back out and then I'll call the case. The court's going to stand in recess.
Good afternoon, Your Honor. Daniel Magoo. Here in Dewey Juris.
All right. So on this matter, I was apprising you of your rights. I told you about the charges in this case. We get to the point of understanding that there is a certain peril in representing.
Listening, sorry. My notes, I apologize, Your Honor. I meant no disrespect.
And that the court will treat you the same as an attorney in the case. You understand, sir? Listen closely to my question. Do you understand that?
I do not understand.
You do not understand it.
No.
The court, you will be presumed to know the rules of procedure as well as the Michigan rules of evidence, that the court will not be giving you assistance in regard to this case.
What I'm trying to say, Your Honor, is I do not understand the charges that are pitting against me because they violate a lot of my rights. And the prosecutor served me the discovery packet on the 27th of last month. Since then, I have not received any kind of evidence or any kind of claims that I violated any kind of anything that day. So I'm here waiting for that to occur. So no, I don't understand.
Waiting for what to occur?
Well, under the rights to due process, Your Honor, 4th, 5th, 8th Amendment, there has to be substantiated amount of evidence to accuse me of a crime, like assault on a police officer, obstruction of justice, and resisting arrest. I take these charges very serious, Your Honor. Because of these charges, I have lost custody of my son.
And I want to make sure that these justice is served and equity is ensured here.
Sir, I just asked you before whether or not you understood the charges.
And I answered you, Your Honor. I said I do not understand them.
Whether or not you disagree with them or not, is not the issue. The issue is do you understand what you are charged with?
I do not understand, Your Honor.
Is there a reason other than what you said that you do not understand?
I can elaborate a little further, Your Honor. I'm still
I
waiting.
wish you wouldn't. I just need to understand why you don't understand.
I'm
the
trying to get there, Your
charges.
Honor, if we could talk
I'm
about it.
not asking you whether or not you agree that you should be charged. I'm not asking whether or not you
You're asking-
believe that you did it. I'm not asking any of that. I'm asking whether or not you understand what you are charged with.
Can we agree to disagree on the legalese?
We are not going to agree to anything. This is not your game to play here. You play by my rules.
So you're saying that I have to say the words, I understand?
Sir, I'm not saying that you have to say anything.
Okay.
I am, you know what? Here's the thing. I am not going to play this game with you.
I'm not.
So what? No, you are playing a
I'm
game.
not.
So no, you are. And do not interrupt me ever again. Do not. So what I'm going to do is I'm going to give you a week to think about it because I'm not going to sit here, call your case up 4 or 5 times for you to sit here and to go through this whole, try to play some semantical game. So I will adjourn this out to December 12th, 2024. I will adjourn it to 9 a.m.
Your Honor,
or I will, do not interrupt me.
I could object to
Do
that date.
not
prior rating.
interrupt, do not. One more time, you're going. I've given you fair warning. I'm adjourning the proceeding out. If you are objecting to that, objections noted. It's still adjourned out to the 12th. Bond will continue. You
Your
may
Honor,
leave now.
I have constitutional.
You may leave
violation.
now.
Let's go. Let's go.
I have a right to a
You may
counsel.
leave.
Do I not have a right to a counsel?
You want an attorney, you may get on an attorney, sir?
I need somebody to explain the problem here.
Do you wish to be represented by an attorney on this?
I do not need to represent myself. I'm presenting myself. I'm the only one that was there in this courtroom. No one was there. I don't recall anybody that was there that day. I'm the only one that knows what happened, Your Honor.
Do you wish
I was
to be
violated.
represented by an attorney? I'm not going to sit here and argue with you. If you wish to be represented by an attorney,
Your Honor, I have constitutional violations
do
that
you
need.
wish to be represented by an attorney,
You
sir?
take an oath to defend the Constitution of the United States of
Then
America.
if you do not want to answer my question, Mr. Allen, he is to be removed from my court. Court does call the case of People versus Jadon Marita.
Good morning, Chico, on behalf of Mr. Marita. Would you say your name for the record?
Jaden.
Judge, today's time and date, we had this matter up before. My client's originally charged with assault and battery. Prosecutors I believe is offering a count 2 of disturbing the peace. My client would like to plead to that. But he's asking if the court would consider a sentence agreement. He's been in jail since this time, which happened on March 20th of 2024. And if he does successfully plead to disturbing police, I believe that's only a 90 or 93.
I don't know why you're asking me that. I've never done that. 25 years, haven't. So why are you asking me now?
There's always a first time, Your Honor.
Yeah.
People change.
And apparently, if you see rainbows and unicorns in the back, it's changed.
Judge,
You see them?
Judge, I've noticed as you've got older and more gracious and stuff, you're more open to negotiations.
Older,
Well, I mean, bench wise, not appearance wise.
older.
I can't save this.
Said,
guy.
Can I have an agreement, old guy? That's what he just
No,
said.
no, that's not was my intention, Judge. Listen, I'll be in the nursing home in the next couple of years, so please work with me.
Think it's gonna take that long? No, but.
So that the offer is to plead to add count 2 of disturbing the peace contrary to 750170.
We tried that before, didn't we?
Yes, Judge, and you said that that we couldn't proceed because there was a victim, but the law clearly states that the prisoner who is in jail, who's the victim, does not have that right except to, may I read this, as an individual who's incarcerated is not eligible to exercise the privileges and rights established for victims under this article, except for he or she may submit a written statement to the court for considered at sentencing.
And that's correct, Joe.
I know that, but thank you for
Okay.
reading it to me.
Thank you.
That still would require, so stay with me here, Mr. Kilwell. If I were to do immediate sentencing, I haven't given that person an opportunity to exercise their right that they do have.
That's-
Correct?
Correct.
So then if I did that, I'd be violating the statute.
Correct.
Which is what I was saying before. Right?
Correct.
And so now you want me to do what I said I wouldn't do before now.
I should retract that. No, I don't want you, well, Judge, we'd like to hear the plea today, and whatever the court deems necessary for sentencing, we'll go along with it.
You still want to plead, young man?
I'll leave it to your discretion. Do you want to, they're offering you disturbing the peace. Do you want to plead to that?
I'll agree to disturb.
You'll plead to that? You understand that I'm gonna have to set it out a period of time. I don't know if anybody will respond to any communication or anything, but I have to set it out so that they can at least try to get in touch with the court prior to issuing a sentence on this. You understand that?
Would I still be able to bond out before? the-
I'll check on that. I'll check on the holds while we, you're on.
Oh, God.
He's got other holds, Your Honor.
So I don't know that I can answer that anyway.
I'm talking about on this specific case, will I have a bond that where I could bond out?
Just found on this case. What do you have?
It's 1,000.
So it's $100 bond on this case.
That's it's not going to get any lower.
No, I don't, before I was asking. if I'd be able to bond out.
Yes, if you pay the $100 on this case, but if you have other holds, you're not going anywhere. That's what the judge is asking. So you still want to plead to disturbing the peace?
You wish to plead?
Yes, Your Honor. So I retract everything I said to you before.
I know you've wasted my time once again. Can I
Oh,
have him raise his right hand to be sworn?
You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that? All right. Still wish to plead? And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You had previously signed an advice of rights form. You recall doing that? All right. Because you're pleading guilty, you understand that you'll not have a trial. Okay, because of that, you're also giving up certain rights. You're giving up your right to call witnesses to speak to you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you, and you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that? You understand you're giving up your right to appeal of right. Are you on probation or parole? Which one? All right, were you on probation at the time of this offense? All right. You were?
I was in, at the time of this offense. I was already in jail for a probation violation.
Got you.
I think he was pending a hearing on a violation, so he was technically on probation
At the time.
at the time of this as well.
Okay, are you still on that probation?
Yes, sir.
All right. You understand that your plea in this case could be considered another violation of that probation.
Yes, sir.
You understand that as such, if it is, that court could sentence you to the maximum allowable under that other charge. In understanding that, you still wish to plead guilty to this charge? Has anybody promised you anything other than what's been stated here today to get you to plead to this charge of disturbing the peace?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily of your own free will. Right, and also because you that you're guilty. On the date of March 20th, 2024, at the location of 2201 Hogback Road, that being the Western County Jail, what'd you do that makes you think that you're guilty?
Squirted bodily fluid under inmate's door.
Okay, and in doing that, that disturbed the peace and repose of the area around you? Yes? And you knew that that's what it did? Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count two. Count one is dismissed. Pre-sentence investigation and report is ordered through probation. Sentencing on this matter will be December 17th, 2024, 9 a.m.
And I was able to verify that will be enough time for us to attempt to contact the victim to see if they wish to provide a statement.
All right, thank you.
Your Honor, will probation come down to the jail to interview him?
I don't know. Yes, they'll get to him.
All right,
Trust
thank you.
me.
Thank you, Judge.
We do it every day, all day.
All right, thank you.
Ms. Fong-Fachan fully understands that the consequences of her actions.
Does she though? Does she? I mean, I don't know anything about what was necessarily alleged in the case other than the charge. Then to hear that recitation of what this case is about and then look at this defendant's behavior, does she really? And I don't know why these kids keep coming up as some shield, because it appears to me everything she's doing has nothing to do with them. I don't understand your stupidity. I just don't get it. Calls case, People's State of Michigan versus Julie Bombashell.
Your Honor, I appreciate the court's accommodation. I had an opportunity to speak with Ms. Fong-Fachan. I discussed bond violations that have come to the court's attention since Ms. Fong-Fachan's last appearance before the court. Ms. Fong-Fachan.
Now that, as well as the continued lie.
Of course, Your Honor. And Ms. Fong-Fachan is going to apologize to the court. She's going to admit that what the court has been made aware of, her participation on a video podcast.
Okay, let's just get it all right, Mr. Warren. Here's the stupidity of this individual. I lock her in jail because she was lying to me and violating her conditions. One of her first calls from the jail is to a podcast. Am I right?
That's correct, Your Honor.
But then gets here and runs a ruse that she's really making the calls regarding her two children. Then, so not only does that then go on social media, there's then another one on social media shortly after when she was arraigned, where she was violating her bond condition at that time. I've yet to figure out why she doesn't have a medical marijuana card if that's what she wants to do. But she doesn't, and then just continues to use. Lied to community corrections, then lied to me. So she gets put in, then makes within that week at least 41 calls that we could see, but there were actually additional ones. Then can't wait a day after being released. Violates my order again.
And Your Honor, that is my understanding of where we are today in its entirety. And Ms. Fong Fachan admits to all of those things. She did go into custody. She placed upwards of 120 to 130 phone calls, one of which was to a podcast. And I think that demonstrates to the court that her statements that she learned her lesson in custody, it may hinder that because Ms. Fong Fachan was laughing, joking on a podcast.
Oh, yeah,
when
she
she-
was. She thought it was all a game.
Of course,
And
That-
guess what? You can think it's a game. It's a game with me that you will never win,
Understand.
ever. No, I don't think you do.
Can't speak.
no. Your Honor, that was the first week she was in custody. The following week, she lost her phone privileges. She was released from custody, at which point she came before the court, apologized for what happened leading up to
And-
that.
Lied to Mr. Feaster, so Mr. Feaster would lie to the court.
Your Honor, I think Ms. Fong Fachan understands that pretrial release is a matter of grace and that for her to remain on pretrial release, she has to demonstrate to the court that she is going to comply with her bond conditions. She has had a turbulent journey on her bond so far. She's had several violations. There are renewed violations. She admits to all of those. She would ask the court to
Including that the THC cookies, the time release THC cookies was a lie.
Ms. Fong Fachan understands that that story is not feasible, that when you
Really?
inspect the claim that was made at her first probable cause conference, that it doesn't make any sense. And she'll admit that today to the court, that a number of things she said leading up to this have not made sense and have turned out to be false. And when a person, anyone puts himself in that position, you have to tell lies and lies and lies to kind of undo what you've done so far. I think Ms. Fong Fachan wants to ask the court for a clean start, to come clean as to.
I thought we did that the last time. This is almost the same spiel I was getting last time, right before she got out and on film dragged.
Right.
God only knows why you'd be mixing anything with Red Bull, but what the heck?
Understood, Your Honor. And she did drink. There's a video of her doing it. She doesn't
Oh, yeah,
deny it.
there is.
And what she's going to ask the court to consider is continuing her bond, upwards modification, that she be placed on a other to monitor alcohol use, that she submit to ETG testing to monitor her alcohol use, and that she cease using social media while this case is pending. Ms. Fong Fachan is serious about resolving this matter. She's serious about taking care of her two children. Daughters Maddie and Ayana have upcoming birthdays on the 28th of March and on the 2nd of April. I know
So it would
she
be
wants to there
horrible
for
if she's in jail on their birthday.
them. It would, Your Honor.
But it doesn't seem to me that she was really caring about them all this time anyway.
No,
Because
Ms.
she would have never put herself in the jeopardy that she's in right now.
Of course, Your Honor. I know her children are her primary concern more than anything else, that she's asking the court in a final act of grace to permit her to remain out of custody, continue her bond with those modifications, to comply. And Ms. Fong Fachan can address the court and come clean about any violations of bond leading up to today.
Go ahead, what does she want to tell me? Mr. Allen?
I just wanted to apologize for starting off with a bad start with you. I hope that start over. I did my time for bond violation for 2 weeks. I messed up the first week. The second week you revoked my phone privileges. I learned my lesson. I had some time to think about what I've done. And when I figured it out, I did have that cup of alcohol on the podcast. I truly thought that it was just no smoking weed, but I didn't know alcohol was a problem. But now I know. I do not have an alcohol problem. I was just drinking.
How am I supposed to know that?
You don't.
That
You
you,
don't.
that now you've learned your lesson.
I know.
Tell me how I should know that.
I know that anything that I say, you probably won't believe because we started off badly.
Oh, and you lied.
Yes, Your Honor.
It's not just little lies, big lies. Every step you've done, you've been lying. So tell me why I should believe you now.
I don't have a reason or any excuse to argue with that. I understand.
Your Honor, I think Ms. Fong-Fachan knows it's not about what she says, it's about what she does. And what she's done leading up to this has not instilled confidence in the court that she's going to comply. We're asking the court to give her an opportunity to demonstrate that she's going to comply with the court's orders and perhaps present herself as a candidate for at the conclusion of this case.
I know you're upset at me.
Oh, I'm not upset because I definitely get to go home today. So I'm not really upset. Go ahead. What did you want to say? You just think this is all a game. That's what your problem is. You do. You think this is all a game.
I can say definitely, I didn't take it seriously the first week. The second week after I stayed in, I had a lot of time to think.
About what?
About, my actions before, during, and now after the fact, even having a drink. And I guess if you want to put me back in jail, I deserve it.
Yeah, you do. You have a CPL?
Yes.
Lost it. You know why?
Not really.
Smoking and have a CPL. That's probably another form you lied on. How bad do you want to make this get, young lady?
Can you say that again?
How bad do you want to make this get? Because if you want to take this thing and make it the worst experience you ever had in your life, I'll be more than happy to indulge you.
I don't.
So whose rules are we going to play by?
Yours, Your Honor.
Absolutely. Problem is, I don't know that you know how to do the right thing. I think somebody that lies as much as you do about everything, it seems, and just kind of does what you want to do, 'Cause you've probably been doing this your whole life. And that's why you can't change.
May I have the opportunity to say a couple of things?
Oh, absolutely. I'm sorry, Ms. Hughes.
I appreciate this, Your Honor. Your Honor said something very interesting. You've probably always been this way, so that's why it's so hard to change. This behavior is exactly what this case is about. She's charged with R&O. She's charged with malicious destruction of a building. She went to her ex-boyfriend's business and kicked his front door of his business. The police arrived and she immediately started lying to the police. That she had just got there, that she hadn't kicked in the front door, that she didn't know what was going on. The police wanted to conduct their investigation, so they asked her to just wait in her car. That's all they asked her to do. And can you just wait in your car? And she took this as an opportunity to defy them rather than just listen to them. She told them, I'm not doing nothing. I don't need to go to my car. They asked her again, please go to your car. She decided to cut off Officer Cunningham, not allowing him to speak. He said, well, you can either wait in your car or you can wait in my car. She said, take me to jail, fuck it. Yes, go ahead, take me to jail. So I instructed her to put her hands behind her back, is what Officer Cunningham's report says. She then began to verbally and physically defy Officer Cunningham to the point that Officer Baldwin, another Ann Arbor officer, had to get involved. When Officer Baldwin approached, the defendant turned to Officer Baldwin and pulled her left hand away and said, don't make me swing on you, to a police officer. So yes, this is what she does. She lies and she wants to play by her own rules. So by continuously violating Your Honor's orders, this is just a game at this point. Your Honor, I'm asking that you remand her. I'm asking that her bond be revoked and that no bond be set at this time.
Mr. Warren Green.
Thank you, Your Honor. Ms. Fong Fachan, as the court knows, is a mother. She was previously employed at the University of Michigan, stocking shelves. She lost that job when she was remanded to custody, and I know that she is seeking reemployment. Ms. Fong Fachan fully understands that the consequences of her actions.
Does she though? Does she? I mean, I don't know anything about what was necessarily alleged in the case other than the charges, right? And then to hear that recitation of what this case is about and then look at this defendant's behavior, does she really? And I don't know why these kids keep coming up as some shield, because it appears to me everything she's doing has nothing to do with them. She's just running her world. Go ahead. I'm sorry, I interrupted you.
Your Honor, Ms. Fong Fachan has faithfully attended all of her court hearings. I believe that with added conditions of alcohol monitoring, that the court's concerns about her drinking be suppressed. I know it's difficult to address the court's concerns about Ms. Fong Fachan's dishonesty. I believe she's come before you today and been honest about her past conduct and the conduct even after she was released from custody before court today. I'm asking the court to consider continuing her bond with those added conditions, as Fong Fachan will test today and tells me she will test clean.
Anything else?
Nothing further, Your Honor.
Dr. Young, anything else?
Well, I can speak. I just wanted to say sorry. I've made some mistakes that day when that happened. I didn't necessarily just kick in the door. It was more to it inside. And it just escalated. I was upset. I didn't mean to harm or disrespect Officer Cunningham. I didn't mean it for it to escalate that way. And I hope that I can apologize and make it right. I'm trying to. Since this has happened, my life is in shambles. I'm trying to figure it out. Being in jail I get to sit and think about my actions and, actually learn from them. But being in there, I can't get things done. Like I have to figure out getting another job, paying bills. Not that you care, but I'm trying. I'm trying to make it every court date. I quit smoking weed. If I can be placed on an alcohol tether or have to drop for, urine. I ask, can you still give me another chance?
And you said something very interesting. You said, I don't care, not that I care.
Just now?
Yeah, that's a funny thing. Because actually about everybody that comes before this court, I care. I do. Maybe sometimes to my detriment. I do care. I don't understand your stupidity. I just don't get it. And you're asking me to give you another chance. You got the first chance when you were first out. Put you in. I bring you back. And you put me in a position where I can't give you another chance. So then you're in there another week. Told me that day, you and Mr. Feaster, you had learned everything and you were going to be able to conduct yourself by the court rules and everything else. You don't at 24 hours, you don't make it 24 hours. And you all think you just think that all of this is a joke. Don't get to just have your way because you want to have your way. Always. There's a bigger bully. But if you think I am going to tolerate this, wrong judge.
I know.
I do not like sending people to jail, but I'm going to do my job. And if you can't cooperate, if you can't just do the simple things that are asked, none of this stuff is hard. None of it. But if you've got to pretend to all these folks that this doesn't bother you and you're just too cool for any of this, you're just going to make it, well, okay, so be it. You can sit up there and be everybody's hero. So, Mr. Warren Green, here's what I'm going to do. I'm going to adjourn her preliminary examination. I'm adjourning her preliminary examination April 23rd, 2024 at 9. That is before me. I will give you the opportunity to certainly push him before this court, this defendant's release, but for today, she's going. Defendant's bond is hereby revoked pending a motion hearing. If defendant is released from jail, she will go on an alcohol scram test. Thank you.
Thank you, Your Honor.
They just took somebody back, so I can't bring that one out. Mr. Warren Green, if you have that, you can set that on a Wednesday for any type of motion hearing on a Wednesday.
I will file.
You do that. It's on a Wednesday, so Miss Perroni and Miss, no, Barroso's not gonna help me. Miss Coons. Miss Perroni, Miss Coons can help. If you don't do it, and I don't have that alcohol screening assessment, the only thing that I can really sentence you to is the maximum time. And I don't want to,
Paper,
what?
the paper,
What
with all
paper?
the lists on it. What is Von Schwartz?
That's for your alcohol screening and assessment.
Is that somebody I'm supposed to go to? What does that name stand for?
That's somebody that you need to call to set up an appointment so that they can interview you and do an assessment.
Okay.
And Your Honor, my office,
Today's the date and time that was originally set for sentencing. I have reviewed or received and reviewed the recommendation from probation with Ms. Johnson. She has not, we do acknowledge she has not completed the alcohol screening and assessment through Von Schwartz, and she did miss a test on July 1st. I did discuss this with her yesterday on the phone and advised her to go to community corrections as soon as possible to try to test. She informed me, and so did her father, who is here with her today, that she did go to community corrections this morning before court and was there for about 45 minutes. And they said she was unable to test this morning. We are respectfully requesting that the court not remand her at this time and that we adjourn the sentencing out in August to give her the opportunity to complete the alcohol screening and assessment. She is gainfully employed at St. Joe's. She does not want to lose that job. In the alternate, if the court is inclined to remand her in both speaking with Ms. Johnson and her father, our request would be to potentially allow that remand to happen a couple weeks in the future so she can take time off work at St. Joe's so she does not lose that job. Other than that, Your Honor, we respectfully request an adjournment of the sentencing.
and Teresa Claire on behalf of probation. Your Honor, I did communicate with community corrections this morning. She did go over, and she wasn't scheduled to do a test today, so she did not test. She did do her download of her scram. I just confirmed with them that there was no violations on the scram. However, she had not reported to them after June 15th. So there was quite a bit of info that they had to download on that. So I do know that there was no violations on the scram. However, probation also wants to point out to the court that this court did direct her back on April 3rd, I believe, and warned her about any further mistesting. So she was given a warning by this court back in April about her remaining compliant with the testing.
Why?
Why what?
Why'd you miss a test? I mean, I gave you a huge break back in April and just told you, just don't miss the test. You remember that, right?
Yeah.
And then when you pled, why didn't you do your alcohol screening and assessment?
Forgot to print it out.
What?
I said I forgot to print it out.
Oh. They do so much. I mean, I didn't send you the last time. I'll re-refer to defendant to Von Swartz for completion of her alcohol screening and assessment. Young lady, understand something. If you don't do it, and I don't have that alcohol screening and assessment, the only thing that I can really sentence you to is the maximum time. And I don't
The
want to,
paper,
what?
the paper,
What
with all the
paper?
lists on it. What is Von Schwartz?
That's for your alcohol screening and assessment.
Is that somebody I'm supposed to go to? What does that name stand for?
That's somebody that you need to call to set up an appointment so that they can interview you and do an assessment.
Okay.
And Your Honor, my office, I know that the clerk's office sends things out. My office also sent an email to her on June 5th, which gave her the packet and the information for the alcohol assessment in addition to the information to complete the victim's impact.
Need to pay a $75 referral fee. Do you have that?
No.
Adjourner sentenced at August 28, 2024, 9 a.m. Young lady, you are leaving me with no options. And I have a feeling that if you don't follow this, that I'm going to end up sending you for the maximum time. I don't want to do that. I'm going to end up finding you in contempt and sending you. So in this, I'm going to, for the bond violation, I'm going to remand her for 3 days. Washtenaw County Jail for the bond violation. Defendant's remanded. Just go. Is that Dad?
Yes, Your Honor.
Get her back. Dad. Hang on 1 second. Go ahead, take her back. Come on up to the, can you come up to the phone? What's your name, sir?
Tony Johnson.
Okay. Can you help try to get her through the,
Yes, I will definitely make sure that she does it. She lives with her mom, so I don't kind of know the things that kind of goes on. So I'm just coming to support, and I just was hoping that you didn't take her to jail because
I know.
she need this job so bad.
I know, and I, trust me, I did not want to. I just, Miss Clara, can you give to Dad the Von Swartz information and the victim's impact information so that he has it, so that I get where he is, so that he knows what she has to do.
Yes, Your
So
Honor, I do know, I heard him in the hallway, really getting after her for not doing things. So I think that he will.
Well, I don't doubt
If
that.
it's not by my office, or I'll ask them to give you the paper printed out.
Is that in this
It's
building?
right down the hallway.
Okay.
And so I'll tell them you're coming right down.
And,
Okay.
I have the $75 for any fee or whatever that she might have needed to pay. I do have the money, so.
And good afternoon, Lord Daddy, Assistant Public Defender, with on behalf of Mr. Merrick, who's here to my right.
All right. Your name, sir?
David Merrick.
Thank you. Ms. Yagi, your motion.
Thank you, Your Honor. We are asking for reduction in Mr. American's bonds. I won't go into all the detail I did in my motion. I'll just mention a few things recently. Obviously, I know the court's well aware he's been in jail for quite some time. And the biggest thing that I wanted to highlight today are the changes that have taken place during his incarceration. I think one of the biggest ones is his meeting with EMH, his medication. He's now stable on his long-acting medication, injectable. I've been in touch with his sponsor and his parents, all of whom are very supportive. His sponsor told me that he has a great network of people. His sponsor's name is Patrick, and Patrick told me that both Patrick and Mr. Merrick have a network of people, a sober network of people. There are meetings that I know Patrick attends at the Alano Club weekly. There are also Zoom option meetings that they've been talking about. I know Mr. Merrick has interest in going to the Alano Club for the meetings with Patrick, weekly meetings. And the other thing that I just want to highlight, because I just spoke with his parents again, well, his mom again today, and his mom told me that she notices the difference in the way that Mr. Merriquin is speaking in terms of, ironically, his mom said that when he gets out, he needs to come up with a schedule. He needs to come up with, this is what I'm gonna do today, and this is my business I need to take care of. And she's already been talking to him about that, and she told me that Mr. Merriquin is actually nervous about messing up, and he actually really wants to do what he's supposed to do. And she told me that that's a difference, because if he really is motivated and nervous and wanting to prove that he can do it and he will comply, she thinks that's a good sign. And so she, that's something she shared with me today. And she basically has been talking with him about that plan moving forward. He has a social worker at his apartment who I verified actually would come to him. So if he's released, I said, where would you absolutely need to go if you're released? And it's his apartment. His social worker could come visit, or social worker, caseworker, whatever.
Yes.
Yeah, would come to his apartment to sort out his housing issue, try to, get that payment, get that sorted out. And then, that would be step one, and then the meetings, would be step two. But it does seem like he is in a much better place now than he was previously.
All right, and his housing is in place?
His apartment is in place. His mom was there this week, and yes.
All right. Response. All right. Mr. Merriquin, it's like you've been here forever.
I get to take a seat, Your Honor.
Yeah.
A seat.
Yeah. As Ms. Yagi was talking and arguing, and she was talking about the differences in you. A lot of times people think judges are sitting up here and they don't notice differences in people, and I notice a difference in you. There was a point where you came in, and I don't know if you recall this, you had actually been before me on something else. You then came before me that time. And I'll just tell you, you were in bad shape.
I've had plenty of time to stabilize on my meds, get right with my 12-step program, and basically make myself fit for being on the streets, because honestly, I wasn't.
Yeah.
I was right where I was supposed to be good.
Yeah.
And right now, it's like, I feel like if I'm released, whatever the conditions are, I'll be able to meet them because I'm competent and I'm sober, and I'm working a program.
All right. How many AANA meetings do you go to?
I prefer to go every day, but if I'm on home confinement, I could see shaving that number down just a little bit, because it's kind of hard to get a hold of Mr. Casey every day,
Right.
I just kind of leave to go to my meeting or wherever I'm going to go whenever I can get a hold of him. So it's like, 2-3 times a week would probably be just as good as 7.
Well, maybe. Let me ask you this. Do you think you need home confinement?
Honestly,
David, be honest with me. I mean, here's what I want. I would like to release you, but I want you to be a success. That's the most important thing to me.
So do you want to know the truth of the question you just asked?
Yes.
If you release me without home confinement, you may as well leave me.
Gotcha. You know what? No, I know. And
I do plan on, if there were home confinement granted, to comply with it. To not tell Mr. Casey I'm going somewhere and then go somewhere else like I did before.
yeah. Okay.
I discovered that was not the way to go.
You know what, David? You just gave me the answer to whether or not I should release you. Because I'm going to tell you, if I had asked you that question before, you would have lied to me. You would not have been able to bring yourself to tell me that you needed that.
It was hard to admit to
Yeah.
you and to myself.
Yep. All right, here's what I'm gonna do. I'm going to, and I'm gonna do it this way, Michelle. I think it's probably gonna be the best way to do this. I'm gonna release a defendant on a PR. I'm gonna sign an order for home confinement GPS tether. I will then set another hearing date, but what I wanna see is after he's had a chance to talk with his mother, his worker, they go through details and kind of get himself adjusted. I want an order or something in terms of a plan for how he's going to proceed. Okay.
I think we're set for an exam on Tuesday.
That's correct.
Before who, me? No, Judge Freshour. Yeah, you're right.
Thank you, sir.
Perhaps we could sign me up for. double duty
Perhaps,
that day.
what?
Double duty that day.
You mean double?
Well, I'm in here for that. That comes to you.
Tell you what, that's, well, no, I get what you're saying that, David. David, we're gonna do something a little bit different here, okay? Because your exam is set for this Tuesday, all right? It's before Judge Freshour. What I'm gonna do is I'm going to adjourn that preliminary examination to October 1st, but also before Judge Freshour. So I'm not changing the judge on that, okay? In the interim, that's going to allow Ms. Yagi to get the information that I just requested to me, allow you to settle in, figure out how you're gonna do things, and allow Ms. Yagi to get an order to me prior to that point in time. Okay? That sound good? So it's like double duty, like you said, but it's just,
Are you asking me if a PR bond and home confinement sounds good and then until October 1st?
well, right. You'll be on that till October 1st, but Ms. Yagi's gonna get an order to me that's gonna sort of structure what you're doing in the interim, okay?
Yeah, as long as I can get hold of Mr. Casey to go to my meetings, I'll go to all of them.
Okay.
And if I can't get a hold of anyone, here's the catch. I'm not gonna leave the house if I can't get a hold of them.
Okay, so what I'm gonna do is I'm gonna set your bond at a $25,000 personal recognizance bond, GPS, home confinement prior to release. Okay, so as soon as they can get that on you, so it may not be till tomorrow, but as soon as they can get that on you, they'll release you. Ms. Yagi, I would expect an order within a week or 10 days. Okay, and that way, see it. And in the interim, I'm sure counsel, they'll be trying to work something out to try to resolve the case itself. So this may all work out for you. Okay, David?
That'd be great.
And I apologize, Your Honor, just for my clarification. So prior to the order, would Mr. Merriquin have permission to leave for a meeting, or does that not happen until I get the?
Nothing's gonna happen until he can't leave for his meetings. You'll have to do them by Zoom or else until such time as there's an order in place which structures exactly what he's doing.
Okay, so we'll
Okay.
be in touch very soon, okay? Thank you.
And I'll let Judge Freshour know I took one off of her. I don't think she'll be upset. We'll see. Okay, sir, it doesn't, you seem to want this process to work away. It doesn't.
Maybe that's the disadvantage of being pro se, Your Honor.
Yes, there are huge disadvantages because I think you know what you're doing, but you don't. It's become readily clear to me. You have no idea what you're doing.
Right.
And so I'm gonna ask you, and it's gonna cause some difficulty for you. So I'm gonna ask you again, do you wish to be represented by an attorney?
I do not.
Okay. Motion denied. You can file whatever motion you want, but I'm gonna tell you something, sir. I'm not gonna sit here listening to frivolous motions.
Okay.
I'm just not gonna do it.
That's not my intent, Your Honor.
No, I don't care whether it's your intent or not. 3/4, if not 7/8 of that motion that we just dealt with was frivolous. It has no basis in law at all. You're just filing stuff. I'm gonna tell you, I'm not putting up with that. Are we clear on that?
We are clear.
You're gonna represent yourself?
Yes, Your Honor.
Okay, what are we doing?
To begin, I'd like to just announce a brief summary of the incident that happened.
Pardon?
The incident on October 11th, the reason why I'm here, I would just like to announce a brief summary of what happened.
And that's gonna get us where?
Well, I did file a motion a couple weeks ago for discovery. I do have a copy of each.
Yeah, no, I saw it. Did you get the discovery?
I did not, but I don't think I properly served it on the prosecutor, so I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. So what do you want me to do with your case today?
Well, a few things. I want my bond conditions lifted. I want a
Okay.
discovery. I don't know exactly what the procedures here is. You know that wrongly.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yeah, sorry. But I'm trying my best to do things right. But I just
Okay, you haven't started out well.
sorry.
I'm
here because I'm told to be here today, Your Honor. That's the only.
I know.
So what I want to do.
Kind of goes out in my name. So yes, I know why you're here. Let me ask you this. You want to represent yourself in
Yes.
this?
Yes, Your Honor.
You don't want help?
No.
Okay. So I'm gonna do this. I'm gonna apprise you, if you wish to represent yourself, you're constitutionally entitled to do that. I will apprise you that you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration and $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
I understand.
You understand also that at this proceeding and any other further proceeding, that the court is going to hold you to the same standard the court would hold anybody else to, and the court will not play favorites, the court will not help you out, the court will not be assisting you. You understand that, sir?
I do.
All right. If at any time you wish to be represented by an attorney, and if you cannot afford to hire an attorney, but if you wish to be represented by an attorney, the court will afford you that opportunity to be represented. You understand that?
That process is throughout the whole discovery and trial.
Pardon?
I can be assisted with if I can.
If you
later
request an attorney represent you in this matter, that the court will at that point, if you cannot afford to hire one, the court will make sure that you have one. If you wish to get your own attorney, the court will afford you that opportunity to do that. You understand that?
I do.
So what do we wish to do today?
I would like to first file a request for suppression of this evidence until full
Suppression of what evidence?
of body cams, squad footage.
On what basis would you be doing that?
Miranda versus Arizona.
Which says what?
That I was not read my rights prior to being detained. And because of that, any violations that I could have possibly said that could impede my case.
That's your basis for the suppression of body cam?
That I have the right to be read my Miranda rights and know that anything that I say can be used against me. I was not notified.
So that's your basis
to suppress
the body cam.
I'm not trying to suppress it from the court to see. I don't want it in the public domain. I don't want it anything that happened. I was on the scene, the police were on the scene for 2 minutes. They were dispatched there over a fight.
I don't know what. Okay. You're gonna have to put more in writing for me to even understand that, because as it stands here right now, based upon what you told me, I'm gonna deny your motion.
Deny my motion to suppress under Miranda.
As you're calling it, your motion's denied.
Okay. Maybe I'll formulate my request a little more precise to my specific conditions, but I also am requesting that there's full discovery in this process.
Okay, have you sent a request to the prosecutor's office for discovery?
I have not. No.
Have you asked them, how do I get discovery?
No, I will be doing that.
Do you ask anybody how to get discovery?
I asked a couple of the clerks, but they can't, give too much legal advice. So I'm trying to take as much responsibility for this as I can.
Okay, well, I'm gonna, at this point, deny that motion because there hasn't even been a request for discovery. If you don't get something, then you bring a motion for discovery.
Okay.
Next thing you want to do.
Discontinue all hearings until there's substantial evidence on file.
Okay, that doesn't happen that way. I don't know what discontinue all hearings mean.
I don't know either, Your Honor. I'm just representing myself over here.
This is going to be a long process if you just are throwing stuff out there.
I tried to prepare my best for this. I'm really.
Okay, this was your best?
I'm not
you may want to consider getting an attorney, but I'm going to let you go because you have a constitutional right to do it. But this is going to be a long, arduous process if we're going to go at this rate.
What does the prosecution expect next in this case?
Pardon? What do you mean?
You're asking me for what I want out of this case and what I expect.
I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
That's not going to happen.
Okay, so
I mean,
what do I got to do?
Going home is an option, but the charges aren't going anywhere.
I understand, and that's the end goal of where I want to be one day, acquitted of all charges.
Yeah, I don't mean to interrupt, but I am from the public defender's office. I'd be happy if the court wanted to pass to talk with this gentleman.
He says he wants to represent himself, and if he wants to talk to you, then yeah, I mean, I know, Mr. Gaddy, and I appreciate it, but what do you want to do, sir?
I'm not sure what you're asking me. What are my options, sir? Your Honor?
All right.
What do I want to do?
Here's what I'm going to do. I'm going to take a break because I have to have something happen before noon. I will call the Spanish case up afterwards. I will also then call the one plea, maybe, that we have, and then I'll recall your case in the next block.
Okay.
And then maybe between the time I leave this bench and come back, you'll figure out exactly what you want to do.
Yeah,
and maybe how to do it.
I'll do that.
Or maybe if you want an attorney to represent you to help you through this process, because otherwise this thing could much go south for you.
Yeah, I understand.
Not be good, but I'll let you think about that. That's your call.
All right.
Court's in recess.
All right.
State your name.
Daniel Magoo.
All right.
Your Honor, when the court passed this case and left the bench, the defendant did hand me a copy of his motion. I took the recess of the court to file a response. I hand delivered it to the defendant as well as handing the copy to the court. If I may just respond to the record.
Yes.
Thank you. So this motion was sort of put in 3 different sections, for lack of a better term, and they seem to all, like 1 through 11 in each section seems to be the same item. So I only responded to the middle section, which were the motions and requests. The first motion was to compel the testimony of officers at a deposition. I'm asking the court to deny that, as the court is well aware depositions are not appropriate in criminal court. Does the court want me to go through each one and then make a ruling on all, or do you want to do one at a time?
Let's do one at a time.
Okay.
All right. You got any response to the people's response?
Not for that, Your Honor.
No, motion denied.
Thank you. The second request is request for discovery, where the defendant appears to be requesting that we produce different discovery items, as well as there's a sentence here that says the defendant possesses exculpatory video footage. Request an opportunity to submit it for review. I'm not, if he wants to give us something, that's fine, but I just think he should go through the normal discovery process, and I'm not saying the court not order what he's requesting in number 2, because it doesn't appear that there's been any request filed for discovery that hasn't been fulfilled or completed at all.
Well, here's what I'm gonna do, at least at this point, is I'm gonna deny the motion, that portion of the motion also. When he submits his request for discovery, then I'm gonna deny that one specifically without prejudice. That way he can raise whatever issue he may have.
I agree completely, Art. Thank you so much. Number 3 was particularly troubling to the people, as it appears to be a request for the people to get medical records for some person and give those to defendant. I responded that that request was unclear, but it appears to be that the people execute a search warrant to obtain medical information for an alleged witness who does not appear to be mentioned in the police report currently in possession of the people. Unless otherwise directed by the court, the people would think that this people don't intend to execute a search warrant to seek out private and potentially privileged medical information for this person.
Your Honor, in response to that, I have a FOIA records naming, describing the witness and his shirt that he was wearing, which is the reason why the deputies or the detectives were dispatched to the Puffer Reds parking lot at 3 a.m. that morning. I also have a picture of the witness being right there when I got arrested. I mean, I can show you it. It's quickly available here for me to show you, but I mean, he's really within.
I really would be
grasp.
objective that the defendant showing anything to the court that he has not disclosed to the people.
So given that I do have FOIA on my CAD records for the dispatch record of police when they made comments saying there's a Huron Valley ambulance dispatched for a person due to high intoxicants. I wasn't dispatched through Huron Valley, but this is in my police report. I think this is valid enough to say that he is a part of the same scenery and event.
Do you have a name?
His name is Jacob Spalding. I've known him for 15 years. I was with him throughout the course of the night and was.
So you want his medical records?
I want to, first of all, subpoena him to get his witness, statement on record officially. And I would also like his records due to the nature of why they.
I'm not going to order. I mean, that is, I'm not going to order medical records. If you tailor a request for something that isn't available in another fashion, then that's fine. But I'm going to deny that motion.
Yeah, a lot of my civil procedures, I will be correcting and will not have any more problems with. But as for right now,
your civil procedures,
I'm trying to follow the rules of federal civil procedures, and this is my
federal.
Yeah, this is.
Yeah,
I think so.
Okay, so we're a state court.
Okay,
and this
I'll
is
try
criminal proceedings.
Then thank you for your guidance.
Yeah, so you might want to start there.
Okay.
Okay.
So that 3 is denied.
Huh?
3 is denied, Your Honor.
The whole motion's denied. Yes.
Thank you.
All 3 parts.
Number 4 was to subpoena a witness. I just responded that the defendant should follow the subpoena process that's available to him.
Understood.
Okay. Number 5 was that the defendant is requesting the report produce all audio or video recordings. I said he should go through the discovery process. That's that motion at this point. Like, don't.
It's denied.
Thank you.
You can
Number
give
6,
it to him.
the people, I'm not exactly sure. There's a motion to seal statements.
I don't know what that meant.
I don't either.
What does that mean?
It means any statements that I made under stress to either the police officers when they were questioning me or before, after.
What do you want to do with them?
I would like to suppress them so that they don't hinder my trial experience, as I was not.
What does that mean?
Well, I was not given proper notice of my rights when I was detained, and I was questioned thoroughly afterwards.
You have to file a motion. You'd have to lay out specifics as to how and or another any statement that you made which it doesn't sound to me like was the subject matter of necessarily an custodial interrogation, but it doesn't really matter. You're gonna need to lay out all the elements of that before I would rule on that. But in its form, as it sits right now, that motion's denied without prejudice.
Thank you, Your Honor. My response to number 7, which is the defendant is notifying the court of exculpatory video evidence. Okay, I don't have any response to that, really, beyond the fact that it seems that these are videos the defendant has, and that he hasn't received any videos from my office yet, so I don't see how
I have
to
video.
respond to any piece of this.
I have videos, both FOIA requested from the Ypsilanti Police Department and my own. I was formalizing the process for the prosecutor to build her prosecution.
To do what?
When I requested discovery items that I'm going to do following the rules of civil procedure. That's what I was, yeah.
So this last one, what are you gonna do with that? What do you want the court to do?
I want the court to find on what grounds throughout the discovery process that I'm guilty of these crimes.
Okay, sir, it doesn't, you seem to want this process to work away, it doesn't.
Maybe that's the disadvantage of being pro se, Your Honor.
Yes, there are huge disadvantages because I think you know what you're doing, but you don't. It's become readily clear to me. You have no idea what you're doing.
Right.
And so I'm gonna ask you, and it's gonna cause some difficulty for you. So I'm gonna ask you again, do you wish to be represented by an attorney?
I do not.
Okay. Motion denied.
Number 8, defendant requests the court cancel all current bond conditions pending the.
Motion denied.
Thank you. Motion to continue proceedings. People weren't opposed to adjournments, but this is actually kind of includes several things. The request is to continue all scheduled hearings until requested testimony, evidence, and hospital records are provided. So I don't have an issue if the defendant needs more time to be prepared to have hearing, but I do have an issue if he's trying to say that he can't do anything until we subpoena somebody's medical records. So I'm going to get a search warrant for somebody's medical records and depose officers in a criminal case.
Which both of those have been denied. So by default, that would have to be denied if that's what he's asking.
I've made a note of the new address mentioned in section 10, and then there's number 11 is to seal all indictments. I don't know what this means.
I don't know.
All incident related documents and evidence. I don't know what that means.
What does that mean?
It's reiterating the sealing. Anything that I've said is really.
I don't know how that sealing would take place.
Okay.
I think you really need to think about getting an attorney. That part of the motion is also denied.
That's all. Thank you, Your Honor.
Okay, so what are we gonna do?
Well, I would like a chance to amend the motion.
No, you can file whatever motion you want, but I'm gonna tell you something, sir. I'm not gonna sit here listening to frivolous motions.
Okay.
I'm just not gonna do it.
That's not my intent, Your Honor.
No, I don't care whether it's your intent or not. 3/4, if not 7/8 of that motion that we just dealt with was frivolous. It has no basis in law at all. You're just filing stuff. I'm going to tell you, I'm not putting up with that. Are we clear on that?
We are clear.
So what do you wish to do now? Do you wish to have a preliminary exam set?
Yeah, I'd ask for some for an adjournment in order to review the discovery materials I've produced from my FOIA.
That what?
That I've came up with through my FOIA request. Or I'm going to plan on submitting the procedures as normal through the prosecution too as well, but I need time to review the documents.
What does that mean?
It means I just got the documents and I haven't been able to review them and I need time to review them. Your Honor. I can't decide on something and request for something right now in this moment if I haven't reviewed evidence.
So all you want is an adjournment?
after this response that I submitted to her and she submitted back? Yes, sir, Your Honor. Adjournment for pretrial, adjournment for discovery materials.
You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense.
I understand that, Your Honor.
No, I don't think you do. I think you were just placing words in sentences, thinking that because what you're asking for makes no sense. And if you think it does make sense, then maybe this court needs to send you for a competency. And I'm not saying that jokingly. This doesn't make any sense. I'll grant your adjournment. Next time you'll need to fill out a sheet to do it, but I'm not going to waste the time today to do it because.
Thank you, Your Honor.
And Your Honor, for the record, I've put the email address that Defendant should contact for discovery on this Post-it note, which I'm going to place here, and he can pick up. He's indicated he doesn't want to communicate with me about this case.
He doesn't want?
Oh, at
He
that
doesn't want to
moment.
communicate with me about his case earlier, so I'm not going to speak with him today about this case. So I've given him the Post-it note to get discovery.
Oh, yeah, that's a good way to get this going. All right. Probable cause conference. Me. Yeah, let me at least have some turkey before I have to deal with this again. December 5th, 2024.
It was improper for the wording, Your Honor. I apologize, but my ultimate goal is have the prosecution present their evidence against.
I'm going to indicate discovery is complete because I don't know what you're saying. Because what you just said regarding discovery didn't make any sense. With what Mr. McLaughlin was saying and what he has in writing, that he agreed. You know what? I am not gonna sit here and try to overtalk you because if you keep interrupting me, you're going to be going with my bail. That's called the case of the People State of Michigan versus Daniel Magoo.
Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Magoo, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor and or felony, punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself. In this, you have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If for whatever reason during any point in this proceeding you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth. And thank you. So I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or prelim.
You wish to have a preliminary examination?
Preliminary examination, yes.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals for the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant. And I believe that some of the representations that were made in this writ of mandamus that has been dismissed include
appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that you sort of reconcile both of those things as to whether or not discovery is something the defendant's prepared to move forward, and if he ever intends to file a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my, what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong, as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yeah.
12 noon, that is before me.
Thank you, Your Honor.
And continue.
Your Honor, Alex Henry, on behalf of the defendant, who is also present, Daryl Daniels.
Daniels.
Yes, sir.
All right.
Your Honor, if I may before start, may I say something? Good luck.
Maybe. Go ahead. What do you want to say?
Last time I was here, Your Honor, I was scared and I lied to you.
Okay.
I wasn't honest. I went through this with Mr. McLaughlin. I didn't when they wouldn't let me into my place. So I took the money.
Both sets of money?
Huh?
Both sets?
I took the money. Because I had no place to go. And I didn't know what to do. And I had medications and I was on the street, having no family and friends. And he kept pressuring me to move out so that someone else would move in. And he kept sending me emails and texts that my security deposit was going down. And I really didn't know what to do. And being not able to get back to my place where my stuff is. And I was scared. I truly was. And I didn't want to admit that I was afraid or something like that. You know, I thought it made me seem like I'm weak or something like that. And I found out that it makes me seem like I'm weak by not being honest. And I apologize. Please forgive me.
So you voluntarily surrendered the apartment?
No, I didn't surrender the apartment. No, I couldn't get back in. They had already locked the doors. I couldn't get in. They're standing there. I couldn't get in.
So what are you claiming you lied about?
I accepted the $400.
Which $400?
There's only one.
Well, no. My understanding is there's two $400.
That's what they're trying to say.
Okay, so which $400 did you lie about?
A video that they have showing him giving me $400. This video.
From Mr. McLaughlin's agent.
Yeah.
You took that $400.
Yeah. They came down the stairs and they gave it to me.
Okay.
I didn't want it, but.
Well, hold on a second. Hold on, Mr. Daniels. So you took that $400 and that was the $400 where you agreed to surrender the unit?
No, I didn't agree to surrender anything.
Then why were you getting the $400?
He told me, the gentleman said, Daryl, listen, you might as well, you know, have a place to stay in. And I agree with him, you know, the gentleman won't have me one. And I'm like, I'm not signing anything, that's wrong. He's like, yeah. He said, he said, yeah, I understand.
Well, so
I was right.
Daniels,
Yes, sir.
there's this meeting that takes place.
Yes, sir.
You're given $400.
Yes, sir.
Why did they give you the $400 if it wasn't to relinquish possession of?
I wasn't relinquishing possession.
Okay.
I never agreed to
relinquish. Okay, all right. Then why did you take the $400?
I didn't know what to do. I had no place.
What do you mean you didn't know what to
I
do?
had no place to go. And I don't want to stay on the streets. And
Mr. Daniel,
yes, sir.
what you're saying, it doesn't make any sense.
I made a
So, you need to start telling the truth. So,
I took it because I didn't know I had no place to go. I didn't have no money to get food to eat. I had medications that I had to have. And I didn't know what to do.
Daniel, you had a place. They said, so here's what you told me.
The door was locked. I was locked out. I didn't have the keys to the place. The locks were changed. I had no way of getting in. And if you show the video properly, even the front door was boarded shut. It was X across with wood. I couldn't get in. The locks were changing all that. I come around to the back, and there they are standing at the back door. And I'm like, listen, let me in. And they're like, no. And I, you know, it's like, I got scared, you know, and it's like, no excuse. I do a lot of mental illnesses, mental things, and I thought that they all coming at me anyway. They had broken into my home while staying there, and the tenants that stayed there, I told Mr. McLaughlin, he's like, so what you want me to do? And I was afraid, honestly. But I was afraid that I was afraid that I would react in a way that I wasn't supposed to. I didn't know what to do, honestly. I didn't. Truthfully, I didn't know what to do. And not thinking properly and thinking that I would be smarter than them, accepting it and still coming to report against them for what they've done. That's what I thought. I didn't truly. At the time, you know, everything was happening. I was panicking and didn't want to go through it, didn't want to go on the streets, didn't know what's happening. And they offered money, and I said, okay. I thought I was being smart I apologize. I didn't know what I was doing. I was very scared. Thought I was trying to be able to come here and tell what they were doing to me. That was wrong. Because I was already locked out. The locks were already changed. I thought I was fine. I did. I apologize.
Mr. Daniels, what do you want me to do now that it's been determined, well, you've admitted that you lied?
I was already, as I stated, the locks had already been changed. I was locked out. I want to be treated fairly, done right, but I conducted myself like they did.
Well, that's interesting. You want to be treated fairly because
I treated myself like I did.
well, quite frankly, quite frankly, this isn't about you, because you came here on the date the hearing was set. Mr. McLaughlin was not here. You told me they had locked you out,
Yes.
that you could not get back in your
Yes,
premises
yes,
and all of that, right?
yes,
That basically he had resorted to self-help.
yes.
What that led the court to do was to then set, but now I understand why Mr. McLaughlin wasn't here, because you had surrendered the apartment.
No, the doors were already locked. The locks were already changed. The locks were already changed.
So then I show cause Mr. McLaughlin to come in. He files an answer, he files a response.
Yeah.
We are back here. You go and get legal services.
Yes.
Mr. Henry appears.
Yes.
And at that hearing, you continued to maintain that you were locked out.
Yes. Yes.
And specifically told me that you didn't take the $400.
I lied.
I know. We get that you lied. But that you didn't take the $400, that they locked you out, that then there wasn't this period in time afterwards.
Yes.
You got community mental health because of that to put you up.
Yes.
So other monies got paid on your behalf.
Yes. They did change the locks on the door, Your Honor. I couldn't get in. The locks were changed. I couldn't get in.
Tell me why I should believe you.
Truly, Your Honor. Not telling you the truth the first time it came here, you shouldn't.
I shouldn't believe anything
you.
you are telling me. I do not believe.
I understand, but I couldn't go on, after, sit back praying and think about it. And you've been honest with me, you've been fair with me all the time. And I couldn't
What I do.
tell you no lies. And I had to come tell you today and let you know that. I was just afraid, Your Honor. I was
Afraid of what?
I don't know everything. I was locked out and the locks have changed already when they gave me the money. They're already changed. I'm locked out. And I thought I was based, I don't know. I'm so jealous. I apologize. I won't say anything else, that might say what else can I say? But I was being honest, now I am. I lied to you.
You know something, not only did you lie to me, you recall at the last hearing, I had my bailiff put Mr. McLaughlin under oath, and we put you under oath.
Yes, sir. Yes, sir.
Mr. McLaughlin maintained the same story that he basically put in his written communication and what he had said. He didn't have everything with him. He said he had a video and wanted to make sure that he could bring it next
Mr.
week.
McLaughlin have not been honest.
Oh.
Listen, every time I called other people I was trying to move out of Mr. McLaughlin's place because I didn't like it there.
You surrendered possession. You surrendered possession of the premises.
No, sir.
Yes, you did.
No, sir.
Yes, you did. That's why you took the $400.
Your Honor, as I stated, the locks were already changed before they gave me that. The locks were already changed.
I don't believe you.
I know you would. That's why I have to tell you the truth. The locks were already changed.
You know something?
Here's
No, be quiet.
Pardon?
Be quiet. You lied to this court when you came here, caused me to file an order to show cause, got Mr. McLaughlin in. Mr. McLaughlin had to file an answer to it, find all of that information, do all of that. You go to legal services, they in good faith, Mr. Henry decides to represent you because you're saying that you've been locked out of the premises. We get here, for the second time, that you've been here. Mr. McLaughlin was only here the one time. But we all get here, put you under oath, you give me your story, the story you give me, you lied. Now, in that same time, you are also lying to Community Mental Health, who is paying to put you up as though you had been locked out. You were not locked out.
Locked out.
No,
Honestly,
you weren't.
when he gave me, if you show the video, I come up the stairs, I'm beating on the door to get in. And I said, the gentleman, now they give me $400. The locks already changed.
If that were the truth,
yeah,
then why wouldn't you have told me that you got the $400?
I'm just saying that I took it, you know, because I had a place to go.
Why would you?
I apologize. I have no excuse. I have no excuse.
Your story just keeps changing. Your story keeps changing.
I was hungry when I was here, and I had medication stuff that I didn't have, and I had no place to go. I had a family friends. That's what I'm saying. I had no place to go. As he shows the video, I come, the door's already locked. The locks already changed. They've already changed the locks. The locks already changed. And that gentleman come down and give me $400. The locks already changed on the door. I couldn't get in.
Go ahead, you tell me everything you want to tell me. Because I don't want you to ever say I didn't give you a chance to tell me.
I told you everything. The locks were already changed on the door. When he came down, he gave me the $400, sir.
And I don't believe
And
you.
I took it.
And I don't believe you. I think that what happened here is you took the $400, voluntarily moved, which also then makes sense with what Mr. McLaughlin was saying and what he has in writing, that he agreed. You know what? I am not going to sit here and try to overtalk you, because if you keep interrupting me, you're going to be going with my bailiff. Am I clear?
Yes, sir. I'm not in an aggressive position. I'm not being that way. So I'll leave it if you want me to. Sorry.
The reason you took the $400 is because you voluntarily surrendered the premises. That's what the court's going to find, that you did that. And that the court also believes that you took the additional $400 that was later on given to you. It all makes sense. That's why Mr. McLaughlin said, I will keep, and it's in writing in a text, that he would allow your property to stay there for a month. And then he gave you more money. And you're just taking money and then coming to court, causing everybody all kinds of problems.
I'm not doing.
Oh, no, you don't even have any idea.
I took lumps. Sorry.
You keep interrupting me, so I'm done.
I didn't mean to apologize.
I find that there was no lockout. I also find that he voluntarily surrendered the premises. Mr. Henry, I know this is embarrassing for you because you came here representing your client, believing that all of this had happened. I find you and have found you always to be an honorable attorney and always put good faith arguments. And you properly did the right thing once you determined your client was an absolute liar. And that is, you filed your motion to withdraw. So prior to entering what I'm entering, I'm going to grant your motion to withdraw, find that it's surrendered. This case is dismissed, but you are entitled to possession of the premises. Oh, yeah. It's yours. He gave it up. You want to know what? You keep it up. What did I tell you? You think I'm kidding? Do you think I'm kidding? Then I'd suggest what you do is you turn around and you walk out and don't say another word to me, because if you say another word to me, you're going to go with Officer Mahal. Have a great day. I've been doing this for a minute. I can't believe you're like an amoeba. What, are you absorbing it through your skin like
Yes,
that?
Mr.
I know you would never lie to me.
Hold up, Mr.
I mean, no, you hold up. Don't tell me to hold up. You sit up there and tell me.
I'm not lying to you, Mr.
Oh,
Simpson.
we don't want to do that. We're done. We're done.
Did I smoke weed, baby?
We're done.
Mike Gaddy, Assistant Public Defender, on behalf of Mr. Watkins, who's present. Judge, state your name, Mr.
Lawrence
Watkins.
Watkins.
Your Honor, at this time, I believe Mr. Watkins will be waiving his preliminary examination.
Before we do that, we have a violation report. Do you see that,
Yes, Your Honor, I did see the report.
Mr. Allen? What do you want?
Your Honor, I received the report yesterday. I haven't seen any of the underlying tests. It's my understanding that there was a positive test for cocaine several weeks or in mid-November, if my recollection serves me right. He was counsel for that. He has not had any other positive tests since. There has been multiple tests. Your Honor has the report.
I do.
Your Honor, Mr. Watkins reports that he has not used cocaine. He has not used marijuana since being ordered not to, and that's why I was hoping to.
Hold on, before he says that, if you want me to call over and get the amount.
Well, that's what I was wondering, Judge, if the lab amounts were going, if the amounts were going down progressively with each test, that would be indicative of.
Can I speak, Simpson?
You can if you want to, but you might want to let your attorney talk to you.
No, I don't mind speaking at all. I mean, as far as the marijuana, Mr. Simpson, like I said, since the day I've been going over there, I haven't smoked weed since. And I have no reason to lie to you. Why would I lie to you? I can just tell you the truth. I would just tell you, yes, I smoke, but I haven't smoked marijuana since. As far as the cocaine, like I told my attorney, I was going through my old clothes. Like I wouldn't lie to you. I would have no reason to lie to you at all. I'm doing great in my life. I'm doing everything I'm supposed to be doing. I showed up to court. You didn't have to put a warrant out for me.
Can you order the results of the marijuana? I need levels.
Yeah, please. I haven't smoked at all, period, Mr. Simpson. If I did, I would tell you I have no reason to lie to you. And I can just simply say, yeah, I smoked, I slipped up here and there, but I never have. I never smoked since the day I've been through the report, not one time. Not one time have I smoked, period. Not once.
So what's up with the cocaine?
I told you, like I was going through my clothes. I can talk. I don't mind talking. And I found some cocaine in my pocket. The only thing I did was took it out of my pocket, Mr. Simpson. That's all I did, and took it straight to the. I could have sold it. I could have did a whole lot of stuff with it. But I told you I'm doing so good in my life right now. I took it straight to the toilet stool and flushed it. I have no reason to lie, Mr.
So
Simpson.
why is it showing up in your system?
I don't know. I just touched it, Mr. Simpson. I never used cocaine in my life, ever. Just touching it.
You know,
Mr. Simpson, I would never.
No, listen. I've been doing this for a minute. I can't believe you're like an amoeba. What, are you absorbing it through your skin like
Yes,
that?
Mr. Simpson.
Oh, okay.
Mr. Simpson, I promise you.
Give me the levels on the cocaine too, please.
Yeah, please, Mr. Simpson, I wouldn't lie to you. I have no.
Okay.
Why would I lie to you?
Here's what yes.
The levels for the cocaine were actually included in the original report the court has. It's pretty small print. It does say 162 nanograms per milliliter for the cocaine.
Oh, I see it. They put it in there.
And it was confirmed.
And I sent that to the. I had.
So,
go ahead, Mr. Simpson.
I don't know how you get 152 milliliters. How do you do that?
Can I talk, Mr. Simpson?
I would.
Well, you've been talking.
Oh, listen, please, let me clear this up to you. There's no.
You're not doing a very good job.
Mr. Simpson. I know you want him to talk, but let me talk, please.
No, I'll let anybody talk that wants to talk to me. I'm just telling you, you are not helping yourself.
I know. I don't see how, since I would never lie to you, ever. Ever. I've never used cocaine in my life. Only thing I did was touch it. Ms. Willard was right there when I showed her. And I took it straight to the, I don't know if it stayed in my system when I flushed it or whatever, but I could take a lot of tests. I've never used cocaine in my life, Mr. Simpson.
How does it stay in your system when it didn't get there?
When it didn't get there,
You took cocaine out of some old clothes,
right,
took it right from there to the bathroom.
I didn't say old cloud out of a jacket I had that was in storage, Mr. Simpson. I would never.
Okay, and then I know you would never lie to me.
Okay.
And so then you didn't do anything with that cocaine.
Mr. Simpson, I
And
never.
then somehow or another that gets into your system
Yeah.
at these levels.
Mr. Simpson.
Oh, you
Yeah.
got to be kidding.
Okay,
me.
listen.
Tell you what we're gonna do. I'm gonna wait for the levels to come across. In the interim, Mr. Allen, take him back, put him in, and then we'll bring you back out.
Okay,
And then I'll do that.
Okay,
I'd let you talk.
I know, can I just say one more thing?
Sure.
Listen, Mr. Simpson, this is what I'm trying to tell you. I call every week and go drop, right? If I'm using cocaine, there's no way in the world I would have went over there and dropped. I would have came in, I would have called over there, told him something, and missed the whole thing, Mr. Simpson. I would have missed it. I would have made an excuse. I would have went to the hospital. Or I could have said this. Oh, somebody put some cocaine in the weed, and I accidentally smoked. And it was in the weed. I could have told you all of that. But I'm telling you the honest to God truth, Mr. Simpson. The honest to God truth. I did not smoke no weed. And if I'd have did that, I could have told you that. You're a fair guy. You've been fair with me every time I came in here. Every time I ever came and seen you, you always been fair with me. So I wouldn't stand in front of you and lie to you. And if I did use cocaine, I would ask for help. I've been doing good for 18 months, period. Working every day, taking care of Miss Willer grandmother for 10 months straight. I never lied to you, Mr. Simpson. I wouldn't do that when I know I can ask you for help.
Okay. I'm gonna get levels and then deal with your case at some other point. But right now, you're gonna go with my bailiff. We'll get that information and then we'll bring you back out.
Today?
Yeah.
Okay, Mr. Simpson.
Unless you want me to.
No,
wait.
no, I don't.
Okay,
I really
but if you
don't.
keep talking, it's gonna be tomorrow.
All right, thank you.
Okay, stop talking. Good, there we go.
I wouldn't lie to you.
Okay, I know you wouldn't lie to me. I'm an amoeba, leave me alone. I'm not gonna read these files, I'm just gonna absorb them. What? Court does call the case of the people of the state of Michigan versus Lawrence Watkins.
Absolutely, for the people.
Mike Gaddy, Assistant Public Defender, on behalf of the defendant, Your Honor, who's standing here on my right, state your name.
Lawrence Watkins.
All right. Couple of things. First of all, we have sent to counsel the levels.
Yes, Your Honor, I did receive I did receive them both by email and a printout, and I have shown them to Mr. Watkins. I would. They do. This is for THC. I'm assuming it's for the metabolite, not active. They do show that they are progressively going down, and then they. Well, this document speaks for itself. Obviously, there is a slight jump from 1210 to 1217 of about.
Slight.
Well, I mean.
Okay.
Well, when we look at
to where it was, yeah.
Yeah, and I mean it's 28. I think the bar graph is probably it starts at 60. I mean, if it started at 0, 1210 and 1217, 1210 would be about 2/3 the size of 1217, not 1/10. So, but it does. I don't know if certain things. Obviously, our body metabolizes things at a different rate. There's a significant reduction in the late month of in late November, and I don't know if these metabolite levels can go up with things like hydration or just how active we've been in the way our body's metabolizing. I do know that since October 29th, even in the worst case scenario, these levels have gone down well over 100, looks like over 130 points. I'd ask the court to, if the court's concerned, about this.
He needs to just tell me,
test.
and I don't mean to interrupt you, Mr. Getty, but he needs to just tell me the truth. I mean, that, you know, we can sit there and play this game, but the cold-hearted reality of what happened is he almost goes down to a zero after it kind of falls off, and then all of a sudden it just shoots back up. Then he's trying to tell me that on the 19th of November, that all of a sudden this cocaine through some osmosis process, I don't know how that all of a sudden just gets into his system. So he's just got to start being honest and don't sit up here and say, I wouldn't lie to you, Mr. Simpson, because this tells me you did.
Mr. Simpson, I would take a lie detector test for you. I would go over there.
I'm done.
Okay.
Your Honor, I'd ask the court to, it looks like he's been testing every 7 to 8 days, maybe increase it to 2 or 3 times a week to allow him to demonstrate that these levels will continue to go down and that there will be no further cocaine tests. Maybe bring us back in 2 weeks, revisit this issue on a adjourned PCC if the court's inclined to do that. This was going to be a waiver today, but I can understand the court's concern.
I'm going to adjourn him out 1 week to the 26th, 2024, 9 a.m. This time based upon what the court sees, defendant's bond is revoked, he's remanded.
Your Honor, if I could say, one other thing is that he's been working steady for the last 18 months. He is a caregiver for his significant other's mother. His life is a much markedly different thing now than it was even in October. This is
Well, he needs to tell me the truth.
Hold up.
I mean, no, you hold up. Don't tell me to hold up. You sit up there and tell me.
I'm not lying to you, Mr. Simpson.
Oh, we don't want to do that. We're done. We're done.
If I ever do not smoke weed,
We're done.
I never.
We're
Mr.
done.
Simpson, I'm
We're
not
done.
lying to
You do not yell at me.
I am not
Ever.
lying.
Do not yell at me ever.
Hold up. This is the
Ever.
first time
No,
ever
you
me
do
telling-
not hold up.
I'm telling
Do
you the
not,
truth,
yeah,
Mr.
you do
Simpson.
not talk to me that way.
Then I can't
You
believe
do
it.
not talk to me that
I'm
way.
not trying to
Ever.
be disrespectful.
Ever.
But I came in here and I was full of garbage. You worked with me. Now I'm telling you the truth, and you telling me I'm lying to you? I have no reason to lie to you, and I know I can tell you the truth. When I used to come in here and I have nothing to stand on, you gave me every chance in the world, Mr. Simpson.
I did. That's why
I can't believe it.
why I expect the truth from you.
That's what
I'm looking at the
you.
graphs.
Even when I came in here, I was full of garbage, Mr. Simpson. You let me go. I'm telling you the truth now, and you think I'm lying to you? I'm taking care of her grandma. I've been doing this for 10 months straight. I've been working. I'm paying child support. I got my name on the lease on the house. I never came in front of you and I had these things accomplished. Now you think I would lie to you? When I know that you're a man and let me finish talking, please. I didn't mean to yell at you, Mr. Simpson. I got the utmost respect for you, and I always have. I'm sorry. But I wouldn't lie to you, Mr. Simpson. I promise you, I'm so sorry for raising my voice. But I wouldn't lie to you when I know I can tell you the truth.
Don't ever do that to me.
I'm sorry, Mr. Simpson.
Shut up right now. You don't ever do that to me. Shut up. And I know my mom taught me better than that, but you better shut up. Shut up and turn around. Just shut up. I sat up there and I listened to you. I did all of that. I don't believe your story about the cocaine. What I was serious, do not say another word, because if you say another word, you're gone. I'm done. I went over and I said I was hoping that the graphs would come back and they would indicate to me that you had not used THC. I was hoping there was something in your story.
Man, I ain't lie to you. Hey, babe, what's the phone number? I'm sorry, just take me to jail. Babe, what's the phone number?
Go.
What's your phone number, babe?
Just go.
Yeah, man, I'm tired, man. I ain't lying to you. You think I'm lying to you? Just take me down to man. I am not lying to you, man.
Ma'am, I'll hear from you, but he's not here. I'll hear from him. What's your name?
Amanda Marie Willard. I don't know about the cocaine issue. I wasn't around for that. We got into an argument and he left, and then he came back and said that he dropped 30 for that. The weed he has not smoked at all since I've been since he had to start dropping.
Can I just say?
I don't understand why he came in here and was like that. But ever since we've got together, he hasn't been in the streets. He hasn't been selling drugs. He's got a job. He helps me take care of my grandma who has Alzheimer's. Like, I can't have him locked up. I don't have nobody else to help me take care of my grandma right now. Like, he's really not doing anything but working, and he stays home with my grandma when I'm at work, and that's it. He doesn't even leave the house.
Yeah. Let me just say this. I've worked with him before. And the thing is, what I saw today, I've seen before with him. What I was hoping, one of two things. One, that he would just really tell me the truth. And then, if not, and if he was actually being truthful with me, particularly about the marijuana use, I don't believe about the cocaine use. And I get what you're saying. You weren't there and whatever. I get it. That what he was telling me was the truth. But then I get the levels. And I'll just describe it to you this way. He's at a certain level, he goes down, and then it levels off. Okay, then he drops to basically almost zero. And then, what was that, the 17th? I want to get the dates right for you. And then the 17th, he pops back up again.
Well, I can't explain.
And so
I just know that he lives with me and my grandma. He's not smoked though at all. So I don't understand that part. I don't know. Okay, so does he have a bond? Can I pay his bond right now? I have to be to work at 5 and I have nobody to sit with my grandma. I don't know what to do right now. He's not a drug addict. He doesn't get high. I'm a heroin addict and I've been sober for 6 years. I wouldn't be with somebody that uses drugs right now. And I wouldn't have him taking care of my 84-year-old grandma either. I wouldn't leave her alone with him if he was selling or using drugs. I smoke marijuana, but I am not on probation or anything. I can drop clean for everything except for that. And I thought he could too, but I don't know. Can I just pay a bond or something?
Oh, dear God. Are you from Milan?
Yeah, you know who I am.
I know.
We just went through a whole court thing with my grandma. My mom was neglecting my grandma. She has Alzheimer's. And I went to court and won in court. We won in court to get her. And I just don't have anybody, no brothers, no sisters to help me take care of her.
Stop. Is that the grandma that was taking care?
Yeah, my grandma Susie. She told me to tell you hi. She said you have to be about her age by now.
Wow. Okay. But that's grandma that was running after all of you Willard kids.
Yeah. I'll be responsible for him.
Hold on. Don't do that.
I will. You can take my whole check right now.
How much can you pay him, man?
I have 200 on me right now, and then I get paid tonight. I'll have 600 in the morning. And then he gets paid tonight at midnight.
Lord, I don't even know why. I'm gonna set his bond at 5,000. I'll give him a 10% privilege, so you need to pay 500. But I'm gonna tell you what, you've been before me before, probably every Willard not and has been before me. You know how I am. So you better talk to him. If he comes in here again yelling at me, not listening, trying to manipulate and do whatever, I'm revoking it. I'll leave it his bond to next week. But I'm going to trust you on one thing, and that is that you go talk to him, that you talk to him and tell him, I'm not playing. He knows that.
Can I talk to him right now?
No. So he's going to go down. It'll be $500 if you got to post. Post it by that time, okay?
By what
Yes,
time?
You can post it tomorrow if you can't come up with 500 tonight, when you said you get your check and you have the 200.
Well, where can I pay it at?
You can pay it at the jail. You have to pay it at the jail because it'll have
Down
to.
there or up front
I
here?
think it's up front.
Okay.
During business hours, it's up.
Yeah, it's right during business hours. It's up front. Where is it after hours? IITR down there. Okay. All right.
Okay.
I don't know why. I'm gonna trust you. All right.
Well, I mean, I feel like if I can get my life together after 20 years of street, so can he, and he's working so hard to set himself back. I don't know why he just came in here and showed out like that. I really don't.
I don't need.
I really don't know why he did that.
Then you need to talk to. I'm gonna trust you to talk to him.
I swear I'm gonna do more than talk.
Because you know how I am, and I'll be straight with you. I'll do what I got to do, but you're not gonna come in here treating me like that.
No, I know.
Okay.
Thank you.
So I'm gonna leave that part to you. I'm gonna trust that you're gonna do what you got to do. All right.
Okay.
Tell your grandma I said hello.
Thank you.
You're welcome. They knew the reason. Mr. Lee understood what I was doing and putting me in custody. The prosecutor's office, I think, was under, given the representation made to this court, was under an obligation to contact this court immediately upon notification that those charges were not brought, knowing that that affected Mr. Lee's liberty. And I'm not happy that I wasn't contacted at all.
Can you still use the previous conditions that were in fact with the.
The conditions will remain. They never left. It's just they took his liberty on something that didn't get authorized. You're going to be free to go.
I'm going home today.
You're going to be let out, sir.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who stands to my right. Please state your name for the record, sir.
Don Lee.
All right. Hey, where are we on this case?
Thank you, Your Honor. This is a driver's license case that, and I have discussed this with Mr. Lee. He will be accepting the offer extended to plead to MCL 257.326.
So, Your Honor, I'd move to add count 2 of MCL 257.326, allowing an ineligible person to drive. You accept that guilty plea to add count 2. I move to dismiss count 1.
Let's have Mr. Lee's point.
Raise your hand. Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Don Lee.
This court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. You understand that, sir?
Yes, sir.
And understanding all that, still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand by pleading guilty, you'll not have a trial of any kind, but
Yes.
you signed an advice of rights form, correct?
Yes.
Any question regarding those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal upright.
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's stated here today on the record to get you to plea? Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Yes.
Of your own free will? Because you believe that you are indeed guilty?
Yes.
On the date of February 10th, 2024, Michigan Road near Moon Road, Pittsfield Township, Washington County, State of Michigan, did you have custody or control of a motor vehicle?
Yes.
Did you allow someone who is otherwise ineligible to operate that motor vehicle?
Yes.
Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Anything you want to say before I impose sentence?
Just very briefly, Your Honor, Mr. Lee is asking that the court consider sentencing him to time served. I do acknowledge he wasn't arraigned on this case until September 19th and only has 9 days credit, albeit he was not being held on this case. Outside of that, I just leave it in the court's discretion.
Anything you want to say, Mr. Lee?
And I just wanted to get this over with and keep him going.
You come back on that other thing tomorrow. Is it tomorrow?
On the 8th.
For exam, Your Honor.
Just trying to recall, when I put you into custody, did we set an exam? Is that what we
Yes,
did?
exam is on the 8th.
Before me?
No, it's before Judge Burke.
Okay. All right, I'll take a look at that because I just, all right.
I think I have the file up, Aaron. Did the court have a question I could help with?
Well, I put him into custody, but I know I told him I was gonna take a look at that on the remand into custody on it, because it came as a result of a police report regarding something else happening.
Yes, it was because there is a new case that is coming down the pipe, to which Ms. Blanche said that the warrant was going to be authorized that day, I believe. Mr. Lee advises, and I don't see anything to contradict that, he hasn't been arraigned on that new charge yet, however, but the 2 ones that he was in front of Your Honor for last week for PCC are set for exam, both cases in front of Judge Burke on October 8th. He's represented by Sam Bernstein in one and the public defenders in the other.
Okay, so my question becomes all right, that's right. That refreshes my memory. Where's that other case? Because the thing, I'm not asking.
Okay.
You don't know.
I know I ain't been arraigned on it.
No, I know, but I'm trying, because I don't know, did I change his bond on, I did change his bond on that. He was supposed to then be arraigned on the other case, but that case was supposed to get, there was supposed to be a timing on that case to get down. So I remanded him. He was going to be held on these cases, on the ones that are set for exam. And then that other case was going to come down, expected that he might be in on that case. But if that case hasn't come down, I'm not going to be very happy right now.
Yes, to my understanding, Your Honor, he has not been arraigned on that new case, but the 2 cases that are already set for exam in front of Judge Burke, currently his bond is $15,000 on each of those cases.
Correct. I get that. What?
You raised it was a PI bond and you raised it up.
I put it up because of the representation of these other cases, but those other cases were supposed. What's the status of that other case?
Your Honor, Ashley Lonnie, for the people on behalf of talk about these other matters. So if I'm reading this correctly, other cases was a resisting and obstructing case that was supposed to be coming down. Is that, Ms. Page, is that correct?
I don't think that was, it was involving a car accident and some other stuff.
I don't know the exact charges that were to be authorized, but I know the incident date was before the ones that are currently set for exam.
Right.
That being said,
I know.
Yeah.
Listen, where is that case? Because my problem here is that, and Mr. Lee is certainly not always the most cooperative person in the world, and he knows that. But he got remanded because his other case was coming down.
Correct.
And so I'm trying to, and I think there was a representation that it had been signed off or it was someplace. And the expectation was that case was going to get sworn out. While in custody, he'd be arraigned. And then there would be, based upon the facts of that case, a bond set that was likely or may have, I won't say, I can't say for sure, may have kept him in custody. which is why I did what I did.
That was my understanding, Your Honor.
I just need a little bit more information.
Go, look, go.
I want to understand, Mr. Lee was last before the court for PCCs. The court is saying on the 26th or the 18th.
I think it was a week ago, wasn't it? I think it was,
The 20,
I think it was the 26th. He was before me.
I have some helping right now. So the new case, which does appear to be related to fleeing and eluding charges, dated incident 8/29/9/20 to 9/2. It appears that case was authorized, signed by my office on 9/26. And I don't see.
That's what was indicated to the court on the record, that it was signed off on 9/26. But then there was a representation that it was going to get sworn to. It was signed off by your office. I think that's what was represented to me. It was going to get sworn to so that Mr. Lee could be arraigned on it.
My understanding is that Magistrate Fink signed that case on September 30th. It is likely,
well, then why hasn't he been arraigned?
I'm not sure, Your Honor. It may be in a stack of things that are waiting to be entered. That's been happening.
Oh,
I don't.
no, that will not happen. Miss.
I show with the 14B.
Okay, so it's on the line. Said the swear out was on the 30th. Yeah.
I have a police officer.
Oh, really?
Yes, that helps.
So, whoa. Is that what the log notes indicate?
Yes.
So there are no charges.
Correct. It says court does not find probable cause.
Okay. Just hold. That's what it says?
Yes.
So there is no case.
Can I confirm the police report number for that? Yeah, I have it. Washtenaw County Sheriff's Department report number 24-67821. I have 68821.
And?
I'm checking with Melanie.
Yes, and while you're checking with them, have me bring them Mr. Lee's other two cases that are set for the 8th. Immediately. That's the last one I have. Now.
No.
Okay, let's. Mr. Lee, that's what we're gonna do. I'm gonna have them take you back.
Okay.
And what court does. I haven't sent this yet, right?
You did not.
Okay, I took the plea, but he didn't send it. All right. Court calls case People versus Billy Pauly.
Ashley Long for People.
Court recalls case People versus Don Lee.
Sure, is the court calling felony matters or the?
I am calling the felony matters also.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who stands to my right. Please state your name again for the record, sir.
Don Lee.
And I'm calling so that we're clear, 24 FB 1322, as well as 224 F 1261.
That was 1322 and 24 up to 1261.
The felony matters, yes, ma'am.
Thank you, Your Honor. Ashley Long for the People in both of those matters.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who stands to my right.
I still have to sentence him on the driving well or the operating well. So we've taken a look at it. That complaint that I put Mr. in custody on there was no probable cause found. And so that was not done. And I'm gonna say this. They knew the reason. Mr. Lee understood what I was doing and putting me in custody. The prosecutor's office, I think, was under, given the representation made to this court, was under an obligation to contact this court immediately upon notification that those charges were not brought, knowing that that affected Mr. Lee's liberty. And I'm not happy that I wasn't contacted at all. Anything you want to say before I sentence him on his misdemeanor?
Nothing further, Your Honor. I would just reiterate his request be sentenced to time served on that misdemeanor.
Fines and costs of $250. Those fines and costs are waived in their entirety. 90 days suspended on that case. With reference to his felony matters, those will continue to preliminary examination on October 8th before Judge Burke. Bond on those cases, both will be set at personal recovery. The conditions will remain. They never left. It's just they took his liberty on something that didn't get authorized. You're going to be free to go.
I'm going home today.
You're going to be let out, sir.
Thank you.
And then you cite a portion of that, and I think intentionally skipped over the first part of that paragraph to mislead this court. Court recalls case of the People versus Darren Wilson.
And good afternoon once again, Your Honor. Good afternoon to your fine staff. May it please this most honorable court. Edward Martell, P 85051 on behalf of Darren Dwayne. State your name once again for the record.
Have a seat. So, Mr. Martell, you know, I'm a bit concerned. I just take what people give me. But I'm just going to say this. You lied to me at the very beginning of your argument. I went back, had my staff go back. You said that I held a preliminary examination on the co-defendant. I couldn't recall it, but it's not true. That was an absolute falsehood and misrepresentation to this court. Ms. Hughes then points that out, but I'm still not sure. On the break, I go back, have my staff look it up, which was some doing, but if the case that you're referring to as a co-defendant is Christopher Harrison, that case number for reference is 24F22251, our case number. That is not the circuit court case number. I didn't handle that exam. Judge Barr handled that exam. So your initial argument regarding recusal started with and I hate using the word, but it's true. It started with a lie. Then, Mr. Martell, you continued with your lie regarding the import of the case of People versus Burrell, which you cite one portion of it about a magistrate who takes testimony and does that. And that's why I went through exactly what this court does regarding search warrants. And then you cite a portion of that, and I think intentionally skipped over the first part of that paragraph to mislead this court. And I'll tell you what it says. It says, whereas here, an affidavit presented to a magistrate was in conclusory form, which I'm sure those search warrants were, and did not state any of the underlying or operative fact, and no witnesses were examined, which they weren't, we can perceive no prejudice to the accused in having the magistrate who issued the arrest warrant, which is different, preside at a preliminary examination.
If I may.
If it's not going to be a lie, go for it.
Judge, respectfully.
No, you lied to me.
Okay, if I may, Judge, very briefly, I think the record will reflect it. When I cited or spoke about a preliminary examination, I didn't speak directly as to this court having held it, but it having been previously held. I was not present at that particular examination. However, Judge, certainly I would make no false representations as to who held it or who didn't hold it. I think I just provided that for context.
You want me to play it back?
Judge, I certainly do not, but.
You want me to play it back?
Judge, I certainly, if Your Honor, some other time wants to, that's fine.
No, if you're gonna sit up here and tell me you didn't lie to me, you want me to play it back?
Judge, then I stand corrected, Judge, but I certainly intend to make no misrepresentations of context. The main argument is what it is. And certainly Your Honor is not barred from presiding over this exam. But again, and I've spoken with my client in the basis of just preserving the record and putting forth this argument, certainly mean no disrespect, harassment, or delay to the people. Judge, we're prepared to proceed. If Your Honor intends to deny, that's fine. Again, we're prepared.
I don't know what your motion is, because everything that is presented to me is not it. Ms. Hughes, do people have anything to say regarding this?
I have quite the record to make regarding the one thing that I absolutely have to say, even though I think this argument is clear and where this situation is headed is clear, but the thing that needs to be abundantly clear, I do have a lot to say about the law and I do have my own cases to cite, but if Your Honor doesn't need those, I'll set that aside. But the thing that needs to be said is the search warrants that Your Honor reviewed are what led to the pertinent testimony today. They did not include the pertinent testimony that would be heard today. Your Honor signed off on search warrants that include facts that frankly are not being contested. The defense is not contesting that these crimes occur. They are contesting the defendant's identity. The search warrants led to evidence of the defendant's identity, facts that Your Honor has never heard before, which is where we're about to go. But frankly, the law that I'm choosing not, and maybe I just need to, the law is actually clear that a judge who has reviewed and approved a search warrant, even on facts that they will later hear, that is okay, that procedure is okay. And specifically, I turn to People v. Cameron, which is an unpublished case of the Court of Appeals from 2013, and Cameron is Cameron. And in that case, not only did the judge review and approve the search warrant, but that judge went on to be the trial judge, a bench trial judge. And the Court of Appeals said in that case, so the issue that went up to the Court of Appeals was the defendant was claiming that his trial attorney was ineffective by not trying to recuse that judge. And the Court of Appeals said, failing to advance a meritless argument or raise a futile objection does not constitute ineffective assistance of counsel. That is what the Court of Appeals said about trying to recuse a judge who has previously reviewed a search warrant. The other case that is specifically on point is a much older case. It's from 1971. It's People v. Pitchford, 3-3 Mish at 299, 1971. In that case, the defendant actually, at the preliminary exam, wanted to attack the search warrant that the judge approved. And that judge that had approved the search warrant at issue went on to be the preliminary examination judge. Mind you, on appeal, it wasn't that exact issue. It was more of a statutory interpretation issue that went up on appeal. But the Court of Appeals in that case said the statutory interpretation would have led to the same procedure, that the search warrant judge would have become the preliminary exam judge, and then they affirmed and the case went back down for exam. But in that case, we don't even have a case where the defense is trying to say that Your Honor inappropriately approved a search warrant. And we don't have a case where the defendant is even trying to contest any of the facts that were in the search warrant. Sorry, from having nothing to say, I always have a lot.
No, that's fine. Anything else, Mr.
Judge, just very
Martel?
briefly, and I certainly respect.
Because I'm going to tell you that, quite frankly, Mr. Martel, one may have to convince me why you have not, only in terms of your misleading of this court, attempted to try to have this judge recused for the purpose of forum shopping.
Absolutely.
Because, I think so. Because originally I had to step into this case, and I can tell you, you probably weren't necessarily real excited about it. But that's the way that the system works here. And so I think you're continuing on with that. And because there's no other reason, I think, to try to bring this frivolous argument.
Judge, respectfully, I certainly enjoy practicing before Your Honor, and I certainly had no intent to misspeak this or in fact, I'm gonna pull the exam or the transcript thereafter. As far as I don't believe any misrepresentations were made to this honorable court, Judge. I stand firm on my word. At the end of the day, I think there's a basis for our argument to put forth if it's the position of the court that it's not certainly, Your Honor, we will move forward with your denial and we're prepared.
I have not ruled. You will hear my ruling loud and clear.
Yes,
But do not presume that I'm going to deny it. Before I stepped off the bench, I asked, and I think properly so, your motion should be in writing. How long will that take you to do? If you won't answer me, then I will set the time frame.
2 weeks, please, and thank you, Judge.
Defendant's motion to recuse would need to be filed by December 10th. Prosecutor will respond by December 20th. I will hear the motion on December 26th. This exam is moved to December 26th, 2024 at 12 noon.
Thank you, Judge.
Just for scheduling.
Yes, go ahead. No, that's fine.
I am not available on December 26th. I am
That's-
the person that will be filing the response. I would love to be the person to litigate it as well.
Understood. Then preliminary examination, since this is not of the people's doing, and the defendant, by raising it as well as before, has waived any time requirements, the preliminary examination as well as hearing on the motion will be January 2nd
Thank you, Your Honor.
at 12 noon. 12 noon. Thank you.
Your Honor, that I hope you realize is not possible for me. I'm even being harmed waiting for 2.5 hours on my cell phone, which is on speaker remote
Ma'am,
from me.
then I don't know how I'm going to get you into court.
October 4th of this year, I gave the defendant the proper 30-day notice demanding possession of my property because of non-payment of rent.
Well, okay, let me stop you there.
Okay,
A 30-day can't be the subject of a non-payment of rent action.
okay. So,
All right. Do you want her to move or are you just terminating her tenancy? I mean, are you terminating your tenancy and want her to move or do you want her to pay you?
I want her to move and I want to also have a money judgment. So I can't do that?
Yes, you can do that.
Okay, that's what I want.
Okay. Go ahead.
Yeah, and I'm seeking a money judgment from the court for all back she owes me as of December 1st, 2023, which is $11,995 plus court costs, $215, and service fee of $68.
So how much is your
So the total
claim?
money judgment requested from the court is $12,278.
All right, Ms. Gerler, what do you have to say to that?
Your Honor, when I first moved in, it was to be a temporary arrangement. I had another place lined up that did not end up being represented appropriately. It was to be vacated and renovated, didn't happen. I have attempted along the way to give Ms. Peel, the plaintiff, money. I became extremely ill with COVID, which I have long COVID, along with 2 other disabilities. When I became behind in rent because of illness and sought help from local agencies, the plaintiff was offered money from Faith in Action, and she declined those monies. And there were other monies from other agencies that would have been available that would have satisfied my arrearages at that time of $2,985. Declining those monies led me to believe that she simply wanted me to move out. So I tried to start packing possessions, became ill with COVID again. I have, in the court documents, outlined to you the many times since then that I have been afflicted with every COVID variant. I already have a serious extreme condition of electrohypersensitivity that I cannot easily find a place to live. I cannot live in group settings, be exposed to Wi-Fi, wireless meters, be near cell towers. I need a rural environment. I no longer have a vehicle. I cannot use cell phones, smartphones, computers due to my electrohypersensitivity, and I thank the court for granting this Zoom appointment at the last minute, since I was not supplied the forms necessary in the personal and mailing service I received, and was actually waiting because in our December 1st hearing with Judge Barr, he informed the plaintiff that she had filed incorrect paperwork and needed to refile. So I have been waiting for that paperwork to come, which I don't know, something changed and was not necessary. But
What incorrect paperwork? I don't have a notice to that.
Well, and that's whatever happened, Your Honor. That's what I heard in court, and I'm not privy to what happened thereafter. I am chronically ill, Your Honor. When I get well,
Ma'am, hold on. Yes, ma'am.
I spoke with my attorney counsel yesterday, and she said my paperwork was fine. I think it was just not clear to Judge Barr what I wanted because I didn't know how to present my case. So,
well, yeah, I actually see what Judge Barr is saying right now. Well, you filed 2 different notices. That's why. I got it. It's fine. I think. Hold on. That's not that one. Right. You filed 2 different ones, but you've got, it appears to me, the correct paperwork.
Your Honor,
So-
just to respond, that's what I heard from the judge. And my legal
Yeah, but
counsel,
this is another judge saying that that's wrong. It's correct.
and that's fine. I have no problem, but I was
Okay,
waiting
good.
on that paperwork. I know that the plaintiff is someone who tries to do things appropriately, but what did not happen appropriately with this home that has been a long time rental is that there is no certificate of compliance on file with the township. And the
Okay, so
application-
when are you going to move then?
Your Honor, I have had to deal with all the demands of the court, so I cannot explore that yet because I was required to apply for SER with the DHS, which was declined. I have contacted every agency available to me thus far.
Ma'am, do you understand she doesn't want you to pay rent and stay? She wants you to leave.
I understand that, sir, but to comply with the court and the paperwork required for this hearing, DHS, that's where I have put my first attentions. I have been packing and moving things out of the house, which they have witnessed, but because of my extreme sensitivities, it is not easy for me to find a place where I can live safely. I have just recovered from my last bout with COVID, which has severely impacted me for the last 4 years and created these issues. And I have also...
Ma'am, I understand all of that. The question becomes, when can you move?
That is a question mark to you and me both, Your Honor. I do not know. I have nowhere to go. I am solo in this world. I have no vehicle. My car broke down June of 2022. And my situation is not a good one because of chronic illness. My energy is not reliable, and sometimes 12 hours in the bed.
Okay, ma'am, I can appreciate all of that. But you also have to understand that the landlord is entitled to her premises back.
I understand that they request their premises back, and I have an appointment with Hawk on Monday. To what degree that will help, I do not know at this point. I have been unable to find assistance from anybody because they say I am not sustainable, because I am now forced to live only on my Social Security income, the house line.
Okay, ma'am. Here's what I'm gonna do, because this has gotta. I understand the difficulties that you're telling. I also understand that the landlord needs to resolve that. So I'm going to set this for a trial. You raised some issues in your answer, but I'm going to set it for now. Yes, ma'am.
When I talked to my attorney, she said that there is no requirement for the compliance regulations in Webster Township where I live. And she's an attorney from Dexter. So.
Oh, they know more. They know more than us
Oh.
here, us other country folk from Pittsfield, or what?
I guess. I don't know. That's what she said. Is that correct?
What?
That's what she said.
I don't know. I guess she's from Dexter, so she knows more than us.
Township does
We're
not
just
issue.
little country judges up here. Ma'am.
I actually called the zoning person too. She
Okay,
said-
and she said, yeah, probably
said-
she agreed.
I'm having difficulty hearing, Your Honor. Could that be repeated?
No. Okay, she went to Webster Township. The issue regarding the certificate of occupancy, it really isn't an issue because they don't require it for rental properties in Webster Township. That's the long and short of it.
I would like to know then why Legal Services of South Central Michigan gave me this form and checked
Okay,
it out.
ma'am,
They must
I
have
don't
obviously
know. You
researched
guys keep talking about lawyers. I've not met them. I don't know. All I know is this. You two are in front of me arguing a case. You have one position, plaintiff has another position. So here's what I'm going to do. I'm going to set this matter for non-jury trial. It will be in person.
Your Honor, that I hope you realize is not possible for me. I'm even being harmed waiting for 2.5 hours on my cell phone, which is on speaker remote
Ma'am,
from me.
then I don't know how I'm going to get you into court.
How is is it not possible for me to continue in this manner, sir? I have been before you to establish the severity of my condition. I become debilitated, incapacitated, ill. I lived in the basement of my prior home for 7 months because of radiation poisoning, and by necessity, where your court is located, there are many electronic communication requirements for police, fire, the cell tower, Wi-Fi for the buildings. I will literally fry and be unable to move. That's why I couldn't come today. This is not a fun scenario. And the landlords are well aware of my conditions. They had mitigated the house. They used Ethernet.
All right, ma'am. All right, look. Do you have any problem if I hold a trial and she appears by Zoom?
I guess not. I've been without income for a long time and my preference is.
Okay, look, folks,
Yeah.
there are a lot of folks out there that
Everybody
are
has
having a
a sad
hard time.
story.
And I get it.
Yeah.
Okay, I have to deal with it every Friday. So I don't know that I can help you with any of that right now.
Right.
I'm just trying to set a trial date. Do you
Sooner
have
the
any
better.
objection to her?
Tomorrow.
What?
Or tomorrow, the sooner the better.
I'm not coming in
Over.
on Saturday. I'm this is not happening.
How about Monday?
No. What? We can do when? What time? 1 o'clock on Wednesday? Oh, no, I can't do 1 o'clock. What time seriously can I do? Non-jury trial, December 20th, 2023. 9 a.m.
9 a.m. Okay.
And you need to appear in person, ma'am. You can appear via Zoom.
And right here?
Absolutely, that's where I'll be.
Okay.
And if I don't get this docket done, I'll be still sitting here from this one.
All right, thank you.
Thank you.
Okay, thank you, Your Honor, for the accommodation for my disabilities. I appreciate your sensitivity to the matter and your humor.
Thank you, ma'am.
Bless you. I will sign off now.
All right. Lakestone Apartments versus Leslie Lewis, recall. Where's Miss Lewis? She's not. You know what? You just have to be quiet. That's part of your damn problem. Excuse my language, but it's true. You have to just shut up. Because I bet you, you've interrupted me twice, and I can bet you when your mom's trying to explain something, and it may not come out as articulate as she may want it, she may not even fully understand the emotion that she's trying to explain to you, you probably don't shut up and listen. Lisa Anderson versus Larissa Anderson. This is going to be a minute.
Hello.
Hello. That's okay if they're backwards. Your name?
Larissa. Lisa.
All right. Okay, this is a termination case, and as I'm recalling, mother-daughter. Is that right? Okay. Is it your house, ma'am?
Yeah, I'm on one of these two. So we're both.
Okay. Are you renting this place from somewhere else?
Yes. It's an apartment.
Okay. So, and ma'am, let me ask you this. I don't have a copy of the lease. Are you disputing that she's also on the lease to the apartment?
No, I just wanted her out for my well-being.
No, I hear you, but I've got to have a legal basis in which to do that. So you're both on the lease to the premises. Is that correct? So you would agree that Larissa,
Her
right?
name is on the lease, yes.
That both of you are on the, pardon?
Because she's over 18, yes, she had to be put on the lease. The Section 8 housing voucher is in my name. And they told me since she won't move out, that I have to evict her.
Oh, boy.
Yeah.
All right. So you've got a leasing agreement. There's a Section 8 voucher. What is the portion of, so how much do you pay?
I pay $374 a month.
And the voucher takes care of the rest of the rent.
Correct.
Okay. How much longer is the lease?
The lease ends in February.
And so of the $300 something, who pays what? Do you pay that?
I pay everything. I pay the lights, I pay the water, I pay the
the rent. She just comes and goes as she pleases.
Okay, pardon?
I stay there. I live there. I buy household needs. I buy the soap, the laundry. I buy the needs for that.
Okay, I got you. But if you don't mind me asking, how old are you?
I'm 22.
All right. So
A single mom with my kid.
I got you. Who also resides there. So what's your position on this termination? You don't think you should have to move? Or what?
I mean, she's my mother. We never like agreed on, it's just rent. She wants me to pay and she wants me to get out. I don't understand why I need to get out. She's my mom. I mean, we've only had each other like for all of our life. And when my dad kicked us out, it was her and I homeless, like at a hotel and things like, and now she's trying to kick me out. I don't know why she needs to do that. The lease is up in February and we both have to leave in like February and like right before the holidays and everything. Like, I don't know. First she tried to take guardianship of my son, and then I'm not dead or like running away. I'm not missing. I'm here taking care of my kid. So that's why my kid and she got denied. And now she's trying to evict me because she didn't get lands. So it's just a whole situation, Your Honor.
Yeah. So here's the thing. You mentioned twice her being your mother.
I just love her.
Pardon?
I love my mother, but I don't think the roles are, I don't know.
You don't think what?
Like, I don't think she loves me the way I love her.
Okay. A lot of powers come with this robe. I can't make people love each other.
Right.
So, or how they do it. But why do you want to kick your daughter and your grandchild out?
I'm not trying to kick my grandchild out. It's my daughter that needs to go. Because I don't.
Okay, but whoa. But
I know technically it is.
That's a package deal.
I understand, but she.
So then my question is, why would you want to do that?
I honestly don't want to do that, but I need this because she's abusive towards me.
Larissa, you don't have a place to go with your child. Is that correct?
I mean, I really have to find a place, but I want to stay with my mom, and I'm not abusive towards her. She wakes up and she starts. My hand. You did this to me on yourself. No, you did it to me on Sunday, Larissa. I did not do that to you.
All right. So if there's any type of violence or anything like that, then somebody needs to call the police, because that's not what I'm here to deal with. I'm here to deal with.
I understand, but she just thinks that I'm going to keep my mom close.
She just thinks what?
She blames me for everything, and she doesn't think she doesn't.
She says she doesn't do anything wrong?
She just needs to go.
Ma'am, and I don't mean this flippantly, but it's just true. A 22-year-old daughter telling you that she doesn't do anything wrong is absolutely normal, even if they're doing the wrong thing.
I understand. I was 22 once.
I know. And you know that you may just be doing the silliest thing in the world. The adults, the real adults, are all looking at you, but they will swear up and down that what they're doing is the right thing. That's just the nature of a 22-year-old. So let me ask you this. If I were to make a determination that it's a joint tenancy, which it is, and so that you can't evict her, what are you going to do?
I already told her that.
Well, ma'am, did I ask you? All right. So that was a 22-year-old thing that just happened there. Do not talk. Do not talk. Do not talk. What would you do? Pardon?
I don't know what I would do. I guess I'm stuck with,
Pardon?
I'm stuck with whatever your judgment is.
Yeah, you may be, but that's kind of what I'm getting at. What's your backup plan?
To find my own place and move out.
Okay, have you done that?
No, because
Because why?
the voucher's in my name. I'm stuck in this lease until the 18th. She has no way of paying it. She doesn't have a job.
Have you asked Section 8 about moving?
I had talked to them about it, but they said that I have to contact the landlord where we're living if they would let me out of the lease early. And no, I have not.
Did you talk to them?
No, I have not.
Why not?
Because I asked them to help me evict her and they wouldn't help me do that. So I don't know.
So what did you want to say? What?
I don't remember.
That was 22 also. All right.
She wanted to work on things with us. She wanted our relationship to get better and she wanted me to see her therapist. And I'm open to seeing her therapist, but I don't think he's like all there, but I'm like, whatever.
Well, okay. Let me just tell you this, because here's what I'm going to do. I'm not going to give you guys my decision today because I don't think you guys are ready for the decision. You haven't explored all of your options and what they do. You haven't explored necessarily all of your options, but you are going to figure out a way to make do. Right? Now, I'm just going to tell you this, and maybe the two of you ought to think about some of these things I'm about to say. Marissa, you tell me you love your mother. Sometimes you have to meet them halfway. You have to have maybe a greater understanding of where they're coming from and whatever. Sometimes that can be, particularly for a young person, it can be grueling because you don't understand why they may be operating in the world that they're operating. But you just have to do it. And you have to go through time. And if you got to go talk to somebody to try to understand maybe what she's saying, that's what you got to do. Because guess what? In the end, you get one. That's all that you get. And young lady, while young people don't think that they think they got all the time in the world and can do all of those things, you get one. And if you blow it, there isn't another one to come along. Right? And from your side, your son's name is Lance. He gets one. That's it. Now, for you, and I don't mean to say this, you're going to get in some trouble, but daughters are challenging. I will just tell you that. I've got one of each. Daughters are challenging. The boy was a lot easier for me. My daughter's 26. I still don't understand. I listen. But she's going to operate in her way. And when I tell her, you've got to meet your mom halfway or try to understand. You know what? You just have to be quiet. That's part of your damn problem. Excuse my language, but it's true. You have to just shut up. Because I bet you, you've interrupted me twice, and I can bet you when your mom's trying to explain something, and it may not come out as articulate as she may want it, she may not even fully understand the emotion that she's trying to explain to you, you probably don't shut up and listen. You ought to try that. It can be cathartic. If you love her like you have proclaimed here, you would do it. Ma'am, sometimes you just have to understand. That's a whole different generation than you probably grew up. Her whole thought process is just different. And you can see it just by what's happened in this courtroom. You have not once during this proceeding interrupted me at all in terms of what I'm saying. This one, it's been at least twice. You may not like it, but in some ways, that is what it is, at least at this. you have to accept the fact that if you offer for ways for her to engage and she doesn't want to engage, while it hurts, you just have to let it go and you don't try to force it. Because if she doesn't understand that she doesn't get another mother, that's not your problem, that's hers. You got me? And it sometimes I see it all the time. It can be one of the most painful things in the world because that person in front of you is at least half you, and you can't believe they're acting the way that they're acting, and it hurts. So what I might suggest, if your mother is offering that you go to counseling, whatever you think of that person, whatever, maybe you show the gesture to your mom and go. So here's what I'm going to do, ladies. I don't think this is going to be sorted out in any given period in time, but I'm going to give you at least a week to try to figure it out, act like grown-ups, and maybe the two of you, and I'll say it this harshly, maybe the two of you should stop being so selfish and think about that little guy, Lance, and think about that he's got these two women there that he's got to figure out what they are, and neither one of you are acting in an appropriate fashion for him. So I'll see you guys in a week, oh joy, at 2:00. Start acting like adults, figure it out, come back and tell me something. Wait, what?
It says school, and I have to pick him up.
2:00, figure it out. Next Friday, 2:00, figure it out. Have a great weekend. Seriously, you're going to walk ahead of your mom? Thank you for opening that door. Otherwise I was going to have somebody come out there and snatch you up. You just, quit talking to me. Jeez, Pete. If my daughter did, that would not be a civil case. I almost want to go down the hallway and just run up. No, okay. Really, I can make it right. I'll take my robe off. Okay. You don't let me have any fun. Okay. Sycamore Meadows versus Deja Top. Oh, no, you were sure that day you had gotten away with it.
No,
Yeah, you were. Ma'am, I watched you as you walked out of this
I was
courtroom.
nervous. I was scared. Like, I don't know if it was a video.
You know what? Let me tell you something. You can try to play a game with me if you want. I watched exactly how you walked out of this courtroom. Like you had gotten away with something. And when that video came in, but there is no doubt in my mind that day, you just felt so self-assured that nobody was going to find out. Nobody was going to do anything. I'm not getting caught. I'm not doing this. And like I said, within a matter of minutes, that video shows up.
With on behalf of Ms. Evans, proceeding.
All right. Your motion, sir.
File the motion for bond, Your Honor. I think the storyline of that motion, as the court can tell, is that Antoinette shouldn't have done it. She's sorry that she did it. It's not going to happen again.
I apologize. It was honestly a big mistake.
It was obviously a very big mistake, Your Honor. It was a poor decision. I mean, she wished she could go back in time and stop it, but she can't. She's tried to take some proactive actions, deactivating her social media account. She turned herself in the next day. She called the police and said, I have a warrant. I need to be turned in. So I am heartened by that, Your Honor. A lot of people, when faced with a warrant, they leave and they don't come back for months and months and months. Antoinette made the right decision by turning herself in. She's been there for a couple of weeks now. I mean, she's had some time to reflect on it. The way she expressed her feelings about the case was wrong. It was inappropriate to do that.
I mean, I was sleeping with this lady, Your Honor, and I didn't know nothing about this case. Like, and it's like, I was frustrated. And I just feel like it was wrong for her not to tell me that I had to say something.
There's a lot of frustration there, Your Honor, as the court can tell. And we got the video. I think, so the video was actually taken back in December. I don't know that at the time, I mean, that there was a no contact order between her and the mom. There is now. And she is absolutely going to respect that 100%. She's going to respect the social media, no social media 100%. She deactivated her Facebook, which I think is a step in the right direction. And she is very much feeling the sting and the reality of what happens when you air out business that shouldn't be aired out, Your Honor. That was something that she did that she can come before the court and say, I'm absolutely not going to do that again. She's hoping that this court will give her a second chance to be out there, to follow the rules. She has worked a job now for 11 years. She can still work the job if she gets out. But I think if she's in for a long time, it's not going to be there forever. She's been sitting there for 2 weeks, Your Honor, thinking, you know, I shouldn't have done that. And I think she's coming to the court in a place where she's not going to make that same decision again, Your Honor.
Your Honor, yeah, this is one of those times where I'm actually at a loss for words. This is completely appalling. This is far beyond frustration. This is cruelty. It's re-victimizing a child and her mother. It's disgusting, quite frankly. I'm going to leave the rest of the court. Mr. Bert's done a fine job with this motion. I think the fact that she has worked for a school district, and to my understanding, unless I'm mistaken, is planning on going back to support her children, is disturbing. This woman should be nowhere near children, given the nature of her offense. But with that, Your Honor, I will leave it to the court. I think I've made my case clear.
Yes, you did. Do you remember when the accusations regarding Facebook and other things came up at the court hearing?
Me or Ms. Evans, Your Honor?
Yeah, either of you. You were both.
Oh, no, the video
Yes, I
was from
remember.
December 26th.
Well, but there was a question. The accusation came up. And it was basically directly put forth to you from me as to whether or not that had occurred.
Can I say something? Well, I did.
And hold on. And either directly, I mean, I can go back and get it either directly or certainly by implication, it was said that it did not occur. That people's addresses, other things weren't put out there.
Yes, sir.
And I can see in my mind's eye your face as you were telling me that. And I remember you kind of walking out kind of smugly and just so self-assured that you had just gotten away with something. And
No, I knew. I knew.
I'm
sorry.
And then with a matter of minutes, I received the video. I'm going to be honest with you, I was angry because I believe that you purposely misled the court. And you're lucky you have the attorney that you do, because otherwise I was just sending people to get you.
Oh, no, I was going to turn myself.
No. You didn't even know there was a warrant out. By the time I got that video, I was just going to send people to find you and tell no one. Because you out and out misled this court. Let the court wrap up first.
Yes, sir.
Anything else you want to say?
I think Ms. Evans would like to address the court, Your Honor.
Well, Your Honor, when I did go, I didn't know if I should have said yes or no. When I did go on live, I didn't know that the video got screen recorded. It was off, so I didn't know if it was a video. I knew it was a video. I didn't know it was still on there. It got screen recorded. That's how the video was still going around. I made that video December 26th, which I wasn't talking about the kid, none of the victims. I was talking about the mother in this case, who I had a relationship with. I really do apologize. I mean, I didn't know it's gonna cause me to go to jail.
Oh, no, you were sure that day you had gotten away with it.
No,
Yeah, you were. Ma'am, I watched you as you walked out of this
I was
courtroom.
nervous. I was scared. Like, I don't know if it was a video.
No. You know what? Let me tell you something. You can try to play a game with me if you want. I watched exactly how you walked out of this courtroom. Like you had gotten away with something. And when that video came in, it would be one thing, and I usually give people the benefit of the doubt. If you had been mistaken about something, if you had, then fine. I'll give you that benefit of the doubt.
Yes, sir.
But there is no doubt in my mind that day, you just felt so self-assured that nobody was going to find out, nobody was going to do anything. I'm not getting caught. I'm not doing this. And like I said, within a matter of minutes, that video shows up. So you can sit there in your head and play this game with yourself about you didn't mean to do this, or you didn't know this, or you didn't know that. You can do that if you want. The reality is you got caught. And if you remember my warning to you, as I said, if there is a video, because the people didn't know for sure that I was going to issue a bench warrant. You remember me saying that?
Sure.
The one thing that you'll know about me is I'm a man of my word. And that's exactly what I did. Motion for bond reduction is denied. Defendant's bond will remain as, the motion is denied. Defendant's bond will remain as denied in this case. We need to set it for a new date. I have this one set for, what date is it set?
I believe it's February 15th.
Judge, given her status, we just set this for prelim date.
You got all the discovery?
Well, I have the paper reports, so I'm confident I have what they can provide me, yes.
Okay.
I'll be ready to proceed.
Pardon?
We're ready to move forward, yes, Your Honor.
People, can you have your witnesses available the 6th or the 13th or the 20th, which would be
I know that the 6th, the 15th, or the 20th.
6th, the 13th, or the 20th.
Morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Beach, who is approaching.
Where?
State your name, please.
Yes, Bobby Beach.
Your Honor, we're requesting an adjournment. Mr. Beach, I'm providing Mr. Beach a copy with discovery today. He wants to review it all before next.
Before I adjourn it, Mr. Beach, you had any controlled substance today?
No.
Mr. Allen?
No.
You had nothing. So if I give you a test, you'll come back clean?
Well, this card right here tells me at your community corrections that I can smoke marijuana and I paid money for it. State of Michigan. Say right here, regulatory cannabis. I paid money, taxes. I should be able to medicate. I just had lower back surgery 2 years ago, St. Joe Hospital. They said either use prescription drugs or use what the state of Michigan provides you, the taxpayers. Mm-hmm.
Okay. Would that be the only thing that would show up in your system?
That's it, Your Honor. I know.
I'm gonna pass the matter. I'm gonna let him go on his own. Take a test, come back, and then I'll decide what I'm gonna do. Despite your ability to use marijuana on that card, you can't be under the influence when you come into court. You understand that?
Yeah, I'm not now. I just woke up. I'm not now.
Oh, you just woke up?
Yeah,
That's why you
early.
didn't know where to go in the courtroom?
Yeah, I just had a
Yeah,
daughter.
okay. No, I got you.
I've been babysitting her
Okay,
this
yeah.
morning. I just
Okay,
woke up.
I'm hearing you. I'm gonna trust you to go over on your own. Let's see what the test.
I'm not smoking coming on court, Your Honor.
Really?
Yeah. I'm not.
Okay, all right.
I'm very
Okay.
coherent.
Okay,
I'm
all right.
pretty-
Then you probably ought to stop talking and go take your test.
All right.
All right? Yeah, that way. You better, yeah, get an order over to him.
Just a one time.
Mr. Fisher, tell Miss Perrin he better point the way, because he's gonna get lost.
Can I address the court, Your Honor?
I'd advise against it. I'd advise him to speak to me first.
If you want to address the court, your counsel has advised you that it may not be possible for you to do so, so.
I and my attorney don't see things the same way. So I would, right now, like opportunity to get another attorney.
Okay, and how do you intend upon doing that?
I beg your pardon? I'm hard of hearing.
Can you hear me now?
Yes, sir.
So with reference to an attorney, how are you intending upon doing that?
I'm going to ask to have another one appointed to me.
Well, it doesn't quite work that way.
Okay.
Your Honor, this is news to me. I did see Mr. Edwards yesterday, and there seemed to be no issue.
So you've actually talked to Mr. Brown?
In this whole procedure, I may have talked to Mr. Brown, maybe about an hour, 15 minutes here, 15 minutes there, 5 minutes here and 5 minutes there.
Okay.
This is my first time ever being in court in any type of way.
Okay. So what am I supposed to take from this?
That I'm not satisfied with my attorney. And I think I should have.
So what are you not satisfied with?
Our communication, my understanding of anything.
Have you been listening to him?
Yes, I have.
You have?
I've been listening to him.
And you're telling me Mr. Brown hasn't properly communicated to you or with you? Because if you're gonna say that, I don't believe it for a minute. He's one of the finest attorneys Washtenaw County has. So you can go ahead and say what you want, but I'm letting you know the perspective I'm coming from.
No disrespect to Mr. Brown.
Well, you're about to then. Go ahead.
Yeah, that's exactly what I'm saying.
Really?
That I don't understand.
Okay, you not understanding doesn't mean that the attorney isn't doing their job. I don't see a basis upon which to take Mr. Brown off this case. Now, if you want to hire your own attorney, you can go ahead and hire your own attorney.
Okay, that'll be the next procedure that I'll try to do then.
So you're going to try to hire your attorney. How much time you need to do that?
I'm not sure, sir. I don't know.
Well, I got to set a date. How much time you need? You don't like the best that Washtenaw County may have to offer, and now you want to hire somebody else. How much time do you need?
Well, first of all, I gotta try to come up with some money.
Oh.
Okay. Then second of all, I have to have someone to help me find an attorney.
Mm-hmm.
Is it a such thing as a promo attorney?
A what?
I may not be pronouncing that correctly, but a lot of dental work done.
Pro bono?
Pro bono attorney, yes.
A pro bono attorney.
Yes.
Meaning one that is a good attorney that you're not paying for?
Yeah.
That's what you want?
Basically, that's what I'm saying. Yeah.
Okay, so you realize standing next to you is one of the best that you're not paying for right now. Yeah, I know. I'm shocked.
I wouldn't challenge that. I wouldn't challenge that.
You would?
I wouldn't challenge. I said, I'm not saying he's not. I'm just saying.
Oh, so now you're not saying he's not.
I've said what I've said.
Mm-hmm.
And
so to the extent that is even a proper motion to permit withdrawal of the public defender's office and Mr. Brown, that motion's denied. I don't see a basis upon which to do it.
So, Your Honor, what I'm going to ask to do is to adjourn this for 1 week. So that
1 week?
Yeah, so that my client and I can have a chance to talk and find out the nature of his discontent.
Probable cause conference will be adjourned. 1 week has what, the 6th? June 6th, 2024. 9 a.m. as your invite indicates, bond will continue. All right, Mr. Edwards, I'm going to make a suggestion to you before you take those off. I'm going to make a suggestion to you.
Yes, sir.
Rather than doing a whole lot of thinking yourself, when Mr. Brown comes and talks to you, maybe you ought to listen to him. And then if you have questions and you may not understand something he's saying, you should probably just ask it. And then you'd have probably a better understanding of what's going on, and we don't have to go through this again. Thank you. Have a great day.
Melton, can you please state your name for the record?
Franklin Joseph Melton.
Okay.
Your Honor, we are asking for an adjournment in this matter as well. The adjournment is as a result of, we sent a request for consideration for an offer to the prosecutor. We did initiate the negotiations. We're just still working on those. So I think a short adjournment would do it. Yeah, if the court so allows.
Oh, were you done?
Yes.
Any response from the people? Probable cause conference, June 13, 2024, 9 a.m. Bond continued.
Your Honor, if I may briefly.
That's where we were going. Go ahead.
I know. It's my understanding that Mr. Melton has CMH Act services set up. Tom Kloss is the individual who's assigned to the case to his matter. He has a set of keys and knows where Mr. Melton's going to be staying. Should he get out, an offer requesting home confinement was also sent to the prosecutor for her consideration as well to see about a stipulation to the request. And so I would just be asking for your consideration as well. It's my understanding that Ms. Tenha is leaving it to the discretion of the court.
Where would he be?
Up on Gulf side. I have a 2-bedroom up there, sir. Tom from Community Mental Health has the key and is ready for everything for home.
When did that happen?
I'd have to pull up the.
Well, no, when.
I'm sorry.
That's not the address that we have.
I think, Your Honor, that might be the address he set up with Mr. Kloss. I don't know what address that he may have given for arraignment purposes. And I'm certain that that was likely different. Is that correct?
Yeah.
Okay.
Yeah, that was a different one. The person's unable to do anything, but Tom Klaus has the key and has everything ready for home confinement.
So, my understanding, and maybe Mr. Bell, you can correct me if I'm wrong, this is my understanding speaking with him this morning, that this individual from CMH has confirmed that he has an apartment with a key for Mr. Melton. And that if he were to be home confinement, that's where he would go. CMH not only would have that address, but would be providing him services there. For the record, I don't have any documents. I'm relying on representation by Mr. Bellinger that he has that information.
Oh, because
Because I thought the person might be able to let me stay. Okay. Understood. Your Honor, to clarify further, during the arraignment, he gave a different address to an individual who he assumed would allow him to stay and reside with that individual. That address that he's now given to Mr. Klaus for purposes of home confinement is an address that he's had for a place that he's had for a year now. So it's his own place.
Yeah, and
On golf side?
I'm sorry,
On golf
on golf side, sir.
He's had that for a year?
He's had his own residence for a year. I don't know what the circumstances were at arraignment to the extent that he couldn't go back there or why he.
What is the Arbondale address?
The Arbordale is where I used to live. I lived there for, I had the address for 22 years. Never missed rent.
Did this get you? Did being in custody get you evicted from that location?
No.
Okay.
We were already to golf side.
Okay.
We were already getting out of there.
Who is we?
Tom Klaus was, and we were moving out of there.
So was Tom helping you do that through CMH?
Through CMH,
Okay.
yeah. It gets into this whole thing that it
Okay.
does, yeah.
Your Honor, if I may, just briefly.
Yes, please.
So what we would want for Mr. Melton is to receive CMH service.
Yes, correct.
If he's able to do so in a way that keeps the community safe and keeps him out of trouble, we are all for that. We understand that we always want to strive for the least restrictive means we can do that. If there is a CMH person who has indicated to Mr. Bellinger that he has a key and everything is set up for home confinement, we will leave it to the court's discretion. What I failed to ask Mr. Bellinger, and I apologize, is whether he's had direct contact with the CMH person, or this is all relying on Mr. Melton's explanation, because there obviously have been some issues with that in the past. So if we can kind of clarify on the record that Mr. Bellinger has been in direct contact with Mr. Klaus with CMH and has received information from him that Mr. Klaus has a key to an apartment that is ready, that would be appropriate for home confinement. We will leave it to the court's discretion.
Your Honor, it's my understanding that Ms. Baltima from our, the social worker from our office has had and been working with him and has had that direct contact. I have not personally had the direct contact, however, someone from my office has.
Okay, so here's what I'm going to suggest. I'm going to, at this time, deny your request.
Okay.
However, I'd suggest that you work with the prosecutor's office, get that information to them. You've heard their position. And I think that's an appropriate position, that if there's some place that's safe that is appropriate for home confinement, that's fine. But right now, I don't have anything concrete that says he has an apartment on Gulf Side. And there's a lot of them there.
Understood.
Did you move in then, or what did you do?
Issues when I go to his house. I can't go there. I have autoimmune issues.
I have also, I wasn't talking to you. Okay, that's nice.
You know what, young man? I'm going to tell you one thing right now, and I'm going to tell you, you better check yourself. So I'm going to give you a minute to go out into the hallway. Otherwise, what's going to end up happening is you're going to be in contempt. I was talking to Miss Cunningham. I wasn't addressing you. I don't know why you felt a necessity to interrupt her as she's addressing the court. So you might as well take yourself out of this courtroom right now. Right now.
Okay, where are we on this? This is set for trial.
Yeah, Your Honor, to refresh the court's recollection on this particular matter, this is an action for non-payment of rent. We had a trial date set for July 26th. The landlord tried to enter on July 25th and was refused entry. We came to court, all of us ready to go forward, and the court adjourned this to today. The court ordered that the landlord enter on the 28th and the tenant provide a list of repairs. The landlord did enter, even though the power was out on the 28th, was able to fix the garbage disposal, came back on the 31st and the 1st to conduct the other repairs. A list was given on the 28th. It's landlord's position at this point, due to the refusal for entry, that any repairs that were so important are waived, and that the list that was provided on the 28th is relevant and has been completed. it's the landlord's position that has been completed, and we are seeking a judgment of possession for the full amount of rent.
Yes, sir. So since we moved in April, I moved in.
Okay, but hold on a second. I just want to go back to when we were here on the 26th.
Sure. Yes.
You didn't permit them to enter the unit.
Right. I requested to remain moved at that time, which was ignored, but they had already been in the unit in June to fix said issues, and they weren't properly fixed. So they
Okay,
a lot of
okay, you can obfuscate, but listen, you didn't let them in,
Okay.
right?
For one of them.
So then. You let them in. You were to give them a list of things that were to be done. So let's start there. Did those get completed?
Yes.
So what are we now fighting about?
The fact that the issue was there for 3.5 months since you move in, many issues. We tried to kind fixed according to the.
Why don't you move?
At this point, I'm just, we'll do the year and then